Open up the hearing on House Bill 167 and hear from Representative Spear, who will fill out a pink card afterwards.
Can you see me over this? My name is Carrie Spear. I represent Nashua Ward 3, and Representative Thomas couldn't be here today because she's introducing 7 other bills, so she asked me to introduce this bill. I'm going to read essentially what she wrote as her comments for this bill, but I have comments of my own to add to it as well. This bill is specifically set up to, let me start that again. This committee has worked for a whole year on banning certain PFAS products to come into, consumer products to come into the state. And we are, the bill that passed is 1649. And we did a lot of work on that, and I think we understand what the problem is with PFAS. This bill is specifically geared to ban PFAS in ski, board, and boat wax. It's a very simple idea. And the reason why I say it's simple is that it's a single product. It's very easy to ban, and all the states around us have already banned those versions with PFAS. Now, the FIS, which stands for the International Ski Federation, which is the governing body for the international skiing and snowboarding, have banned it in 1921. So this is not new. All over Europe, they don't use it. The Olympics don't use it. It's already been done. For reasons that I'm not clear on, they're still selling it out there. And every company that makes the wax makes a PFAS less free, thank you, a PFAS-free version. Now, my husband races both nationally and locally. Nobody on the racing teams in the United States, at least at the national level, use wax with PFAS. There are alternatives. It's not a problem. It costs the same amount of money, and they work just as well because the Olympic teams are using it, and they're not having a problem. And as I say, it's been banned since 2021. So the purpose of this bill is to add that consumer product to the list that we had from the previous bill, the bill 1649. And that's about all it is. It's just to add that one product. And I would like to make a comment about why we didn't add it last time, although we did think of it last time. It wasn't added last time because last time we were concentrating on what ends up in the landfill. These products are directly going into the water. They're not going into the landfill. Typically, they go directly into the water. They're on this water skis. They're on the downhill skiing, on all kinds of skis, going directly into the water. So it's not typically a landfill problem, but goes directly into the water. Now, I wanted to point out that the lakes down here in the southern part of the state are 4,000 to 26,000 times the fish that are caught in these lakes have PFAS at levels 4,000 and 26,000 times the EPA recommended level. And we have a number of lakes: Beaver Lake, Robinson Pond in Hudson, Horseshoe Pond in Merrimack, Canterbury Lake in Salem, and Cobbetts Lake, Pond in Wyndham. You're not even allowed to eat the fish in those lakes. So the problem is pretty bad, and I think it's time to stop adding to the problem. And so that's what this bill is about. Any questions?
Nope.
Okay.
Will anybody else like to testify on House Bill 167? Bruce? So all I can do, I can give my little personal story. There was a period of time, it was about, I don't know how long, it was 5 years ago or something, because uh, I, s- I don't know if it was PFAS or not, because I didn't say it, but for my cross country skiing, I was using the liquid ski wax. It's much easier than the stick that all the professionals use, because then you got to put it up, you got to heat up your thing, you know. Now this was liquid. You just rub it all over. It was great, and but it dried up. It was like the marketplace suddenly disappeared, and I asked the guy up in Jackson cross country ski. I said, "Do you know what happened?" And he said, "I think it was PFAS." So, but the product is now back on the market, and assuming it's PFAS free, I don't know, but it's now I can now buy that product that I was buying that I couldn't buy before. So whether it's PFAS or not, who knows? But we did create in the PFAS legislation, we did create a place where things can be added, and um, we knew full well that things would get added over time. And it just requires the companies who are producing the product to have to report to the state wetlands board. Well, it's not the wetlands, but it's a board with the product, and then they have this national registry now, in which they will check to make sure it's kosher. With that, if I see no more, close the House hearing on 167.
15 minutes ahead of the game.
And I guess I was expecting a little bit more, more drama.
All the chlorinating waxes that we used to use, that's PFAS.
It was PFAS,
Yeah.
Henry?
Oh, yeah. I mean, I restored it.
So if you're going to testify on the next bill, I'm guessing that maybe they're here for the next bill, one of these bills. You have to fill out a pink card. You guys, okay?
Can we fill one out? Oh. See,
Okay. Okay, we'll open up the public hearing on House Bill 312 and hear from the prime sponsor, Representative Moffett. Good morning, Representative Moffett.
Thank you, Mr. Chairman. For the record, I am Representative Mike Moffett of Merrimack County District 4, which includes the beautiful towns of Canterbury and Loudon. I've introduced many bills in many committees over the years. This is the first time I believe I've been in this historic Commerce Committee, so I'm a bit nervous, but I'm sure it'll work out. So on June 21st, 2021, there was a unanimous U.S. Supreme Court decision in NCAA versus Alston, landmark court case, which cleared the way for college student athletes to market themselves commercially in ways that had previously been prohibited by the NCAA. And in a concurring opinion, Brett Kavanaugh stated that antitrust laws, quote, should not be a cover for exploitation of student athletes, unquote. So the ruling gave college athletes freedom, a lot more freedom, and control of their own name, image, and likeness. We call it NIL, name, image, and likeness. So the legal action actually started around 2014 when a former UCLA basketball player named Ed O'Bannon saw imagery of himself. It was him, his number, his uniform, UCLA, on a video game. And he saw that, walked by, and said, "That's me." And nobody asked me if they could use my imagery for commercial gain. So anyway, that was the impetus and the genesis behind the court case. It took, as usual, years. So anyway, so now we have a new sports landscape or sportscape. Essentially, the players today are not unlike pro free agents. There's a transfer portal. Some of you follow sports know that big-time college football players and basketball players, especially football, they're going from college to college to college, willy-nilly. One of them actually finished playing 6 years. They get an extra year from COVID. So it's a different world. Many years ago, when I transferred from UNH to Plymouth State, I had to sit out a year before I could play college basketball. So anyway, all this newfound freedom has created some situations that do beg attention, with athletes now controlling their own NIL, name, image, and likeness. Some see a need for some guardrails, some definition. For example, what if players wanted to endorse or tie in with foreign agents or Chinese companies, just to pick a country? What if they wanted to tie in with casino or sports gaming interests? What if they wanted to tie in with addictive products, tobacco, alcohol, or others? What if I heard a representative from Derry mentioning a cannabis bill earlier? What if a college athlete wanted to sign an endorsement deal with Acapulco Gold, which many of you may not know, that's a marijuana brand, currently unavailable in New Hampshire, I believe. But along those lines, and that's the reason that inevitably something's going to pop up. What if a college athlete does want to endorse Acapulco Gold, which is legal in Massachusetts, but not New Hampshire? I mean, these things are on the horizon. So states have been devising statutes to provide some boundaries with regard to this brand new world of sports endorsement. The measure you're looking at here, HB 312, was modeled on a New Jersey law. It says in paragraph 1 that colleges cannot restrict student athletes from marketing themselves and earning compensation for the use of their NIL, name, image, and likeness. So that's kind of a freedom paragraph. Paragraph 2 requires athletes to be represented by licensed attorneys. Now, some states allow anyone to represent athletes. I used to teach sports management. I used to teach a basic intro to sports law course. And so New Hampshire now does have some RSAs that cover sports agency, but some states allow anyone to be an agent, kind of like Colonel Tom Parker represented Elvis. but a need was seen to protect athletes from contracting with foreign agents or unqualified representatives. So as the committee reviews this, it may want to broaden paragraph 2 to include registered sports agents in addition to licensed attorneys. Paragraph 3 does require sports agents or attorneys to comply with federal sport agent law. There is a federal law covering sports agency. In finally, paragraph 4 it seeks to restrict the endorsement universe for college athletes. In other words, addictive drugs, adult entertainment. You'll note, and we did model this on New Jersey, you will note that firearms and weapons are proscribed as well. And that may not fly in the live free or die state. I'm looking around to see if John Burt is going to show up and say that college students should be able to make deals with gun companies. And I would not be uncomfortable with that.
They could be biathlons athletes.
That's an excellent point, Mr. Chair. Biathlon does involve shooting, and skiing is the hundreds
Bill
of
we
people.
just had.
The hundreds of people watching at home, yes, biathlon, shooting, and skiing. Excellent point. So also, I noticed the section of law 356-Delta:3 already provides some definition regarding contracts. I noticed that this section of law was mostly tenant rights. So that just tells you, OLS and the drafting attorneys, this is a new area. So they had to put this possible legislation somewhere, student athlete rights following tenant rights. The measure about sports agency that we put in law a couple of years ago is in a different section of statute. So just because most other states have laws in this area, does that mean we need to? I was just speaking with the good folks from UNH outside. There's no fire that needs to be put out. The intent of this is to be proactive, preemptive, get this on your radar screens, and inevitably there are going to be some things that are going to pop up that need attention. New Hampshire is not California. We're not New York. We're not even Massachusetts. We don't have a lot of major college sports action or major corporations who'd be getting into serious commercial partnerships. The sportscape is changing. Dartmouth men's basketball, recently unionized, although they backed off of that. Had the union stayed in place, could the union have made a deal with representing the whole team, a commercial deal? It's a moot point right now with the Dartmouth men's basketball unionized effort having stopped. But that, again, is the type of thing that is going to happen, is going to come up, and that we will need to address at some point. But also, small school athletes are now free to similarly make commercial arrangements. It's not just, this is important, it's not just big schools. Division III, non-scholarship, small schools, athletes can market themselves now. Now, I was no Larry Bird. I was a small fish in a small pond. But had NCAA versus Alton, had that Supreme Court case passed back when I was around, I can totally see a fraternity brother majoring in business saying, hey, let's do some posters. Let's do a calendar. Let's see if we can get you to Fred's Ford or the Cellar Pub to be a endorser. Alcohol, by the way, is proscribed. It's one of the things that the laws have prohibited. And when I mention alcohol, when I was in college, the drinking age was 18, so that was different. This legislature, in its wisdom, had lowered the drinking age to 18 the day after I turned 18, and that timing is everything. But that obviously that's not the case today. But whether it's alcohol or drugs or substances, those are things that are out there that need to be considered at some point. So some schools probably already have local policies addressing NIL issues. I just talked, as I mentioned, with the UNH folks, and good on them. They already have started and apparently have some policies in place, and you'll probably hear from them. But what if these college policies differ? UNH has some policies in place, it sounds like, Dartmouth, but what about Southern New Hampshire University? What if they have policies that are in conflict? And this is where someday there's going to be a lawsuit saying, well, College A says their athletes can do this, and College B, my college says we can't. That's not, and then there'll be a lawsuit. So again, some preemptive legislation might put us ahead of that game. For example, if a college student in the band can wear Dartmouth hockey shirts while getting paid for a music gig, why can't the Dartmouth cheerleaders similarly wear Dartmouth hockey shirts and do a calendar for their own profit? Miss January wearing a Dartmouth hockey shirt. If people who have music skills can market themselves, why can't people who have athletic skills in college? So anyway, commercial deals we never dreamed of are going to pop up. And to establish a section of law in this area could provide some early definition and a place to put appropriate future sections in down the road as necessary. I'd be happy to try to take any questions if there are any.
Representative Petrusek.
Thank you, Mr. Chairman. And thank you for taking my question, Representative Moffett. Actually, it's an observation. Line 7 on page 1, I guess, it says accredited four-year institutions. I suspect you are aware that there are two-year institutions that are now accredited and offering scholarships to athletes. So I'd like to see that, considered that you also have for two-year institutions.
Thank you, Representative. Yes, I am aware that there are two-year institutions that do sports. I spent 20 years at a two-year institution, actually, and I coached the basketball team there for 3 of those years. That's an excellent observation. And it's true. It's a very good point because some two-year school, there were different classes. I worked at NHTI, non-scholarship, obviously.
Exactly.
There are two-year schools that do offer scholarships, but whether they offer scholarships or not, NIL, the Supreme Court case means that these students, I'm sure that the wheels are turning. Some of them are thinking of ways to make money as athletes. So good point. We should also acknowledge the fact that there are 2 years.
Further question may inquire.
Thank you, Mr. Chair. Also, on page 2, lines 4 and 5, I would really appreciate if you could get rid of the weapons piece, because when I was in the Explorer Scouts, I was a shooter. And it made me do very well when I went to Air Force basic training. And the shooting sports, I believe, are sports. So I would hope that that part would be amended out.
Yes, thank you, Representative. I already touched on that because when I reread this, that's where the reference to John Burt came into place. He's a former representative who was a very staunch Second Amendment advocate. So again, this was largely modeled on the New Jersey statute, which we fine-tuned. And the gun situation in New Jersey is very different from New Hampshire. And I mentioned that on my own, and you just did too. And if this moves forward, whatever the committee does with it, if you took the gun part out, that would not be an issue for me.
And can I follow up?
I guess so.
Thank you. As I used to live in New Jersey, I'm extremely aware of the anti-NRA sentiments down there. Thank you.
Would you believe?
Would you believe?
Representative Hammond.
Thank you, Mr. Chair. Thank you, Representative Moffett, for your testimony. Just because I don't understand one section, I want to ask you about page 1 of the bill, line 14, that paragraph there talks about international scholarship. If you could just explain, it says their NIL shall not affect the student's international scholarship eligibility, and institutional. That's because I don't have my glasses on.
You're as bad as me.
There we go. Institutional. And it shall not be considered compensation for the purposes of this chapter. If you could just explain what that means, I don't understand.
Sure, I'm trying to find the line. Again, that's on your page. What what line is that?
It's the first page of the bill, line 14 through 18.
Right, my copy doesn't have the line numbers that yours does.
Oh.
B,
1A sub B.
little b.
Yeah,
Little b.
D2, 1, Roman numeral 1, sub B.
1D, it starts, prevent a student participating in intercollegiate
Go back. Accept as.
It's right near the beginning, except as otherwise provided pursuant to paragraph 2, that paragraph.
Section B, Baker.
Don't go away. So, where is that? Is that right here?
I just saw you were talking about lines. and you didn't have-
Okay, well, this one has, thank you so much. That's a very nice lady, whoever that was. So, line 14, except as otherwise provided pursuant to paragraph 2, that line?
Yeah, that paragraph.
Okay. Earning compensation from the use of a student's NIL shall not affect the student's institutional scholarship eligibility. Right. So the concern in the past has been that it used to be if you were on scholarship, the NCAA had prohibitions. You couldn't you couldn't do this. You couldn't make money, endorsement money through selling your NIL, name, image, and likeness. So what 14 says, it refers to this shall not affect the student's institutional scholarship eligibility. In other words, if a college student makes a big deal, and when I say makes a big deal, has a contract and makes a lot of money, that shouldn't take away a scholarship. If they get a scholarship, they should be able to make a lot of money. Real quick along those lines, Terry Rogers, there was a Nebraska football player who was a wonderful football player, and he was on scholarship, and they offered him a deal to be a sports writer, which I've done. And so the fact that this football player was writing a sports column and getting a lot of money for the sports column, they made him take some of that money he made from writing the sports column and take it away from his scholarship, which I thought was terrible, but that's what the NCAA did. This court case has changed that. So now the football player who wrote the sports column could keep all that money, and he would keep his scholarship. So, great question. I see your question, and this would protect students who are on scholarship, of which in New Hampshire we don't have very many. UNH does have some people on scholarship. So if someone at UNH was on scholarship, athletic scholarship, and they made a deal and were making a ton of money elsewhere, and UNH financial aid, whatever, looks at that person and said, "Well, you're rich now. We don't need to give you a scholarship." This protects them from losing a scholarship.
Doesn't the Supreme Court decision already do that?
The question was,
Doesn't the Supreme Court decision say that the schools, the NCAA and schools were originally barred? The students was barred from doing it. Did that decision, I guess we need to get a copy of the decision and see what's in it. But didn't it address the issue of the repercussions of a student doing it, that the school would do this, or was that issue mute?
Sure, Mr. Chairman, I'm tracking you. I'd have to look at the language in the Supreme Court decision, but you're right. The intent of the Supreme Court decision was to free the players to allow them to commercialize their name, image, and
Exactly.
likeness. And the Supreme Court, I believe the Supreme Court case covers that. So,
We got to look and see what the decision said.
right. I know there's statutes all over the country now affirming that Supreme Court case, but there are situations where definition will be
Right, because my fear is what this bill is really doing is saying, okay, fine, we got this decision, but now here's the things the students can't do.
right. Well, again,
And I'm not sure I think that's a good idea. I mean, why shouldn't, if the student wants to do tobacco, wants to do video games, and wants to do these whatever sin that someone thinks that New Jersey thinks is a sin.
Right.
Okay. That if they want to do these things, then who are we to say no, they can't do it? If the Supreme Court had ruled that the NCAA and the colleges can't say no, and I agree that there shouldn't be any repercussions. There shouldn't against the student. But shouldn't we just let bygones be bygones and let them advertise wherever they want to advertise with?
I totally get your point. And live free or die. Again, the first paragraph, the first part of this HB reaffirms or confirms the freedom part of it. There were 4 parts of this, and I hear you and I get your point. I had similar thoughts, and as I said, the language we did use from another state to model this this proposal. And I've already said the paragraph 4, the parts of that I'm not that comfortable with. Basically, I think your question is, should we as a state proscribe or prohibit athletes from endorsing pot? Some people think we should. You'll notice we have a lot of sponsors for this measure, and not all the sponsors are necessarily in sync on whether we should outlaw college athletes from
Got it.
endorsing.
Fair enough. Representative Teresa.
So thank you for taking a question. So the scholarship that you mentioned, is it strictly merit-based scholarship or is it also need-based scholarship?
Good question. The scholarships in question, are they academic or athletic? Is that kind of what your question is?
Yeah, so on that paragraph, we say they shouldn't affect the scholarship. So scholarship can be need-based or it can be merit-based. So does it refer to all the scholarships or it refers only to merit-based scholarships?
Sure, that's a great question. It's an interesting question because there are clearly athletic scholarships and there's financial aid, and there are some scholarships. Somebody could be on a academic scholarship, and so the language here about protecting scholarships. If somebody makes a lot of money, would that impact an academic scholarship? Depending upon what the committee does with this, that's an interesting point that may want to confirm that it also, this legislation would also protect academic scholarships. If a student, perhaps a non-athlete, gets rich from selling their NIL, their academic scholarship should also be safe. I mean, that's the type of thing that's going to be happening more and more with this new world. Thank you for your question.
Representative Gibbs.
Thank you, Mr. Chair, and thank you for coming in to testify this morning. How would this affect need-based scholarships, which are based on how much money the student or the student's family has?
Thank you for your question. How would this affect need-based scholarships? I don't think it would affect need-based at all. This is a sports-related measure directly tied to the Supreme Court case. So need-based scholarships that through financial aid, I just don't see them being impacted unless it's an athlete who's getting money for financial aid because of their athletic situation, in which case the language in here is intended to protect the scholarship.
Further question, may inquire.
So did I understand correctly that need-based scholarships would not be protected?
Thank you for your question. Not by the language in here. That was not the intent. Was to protect need-based scholarships. That would be something locally that institutions, their policies would cover. Again, the focus here was on student athletes, but people in a band, people in a marching band who have wonderful music skills. If they wear a UNH hockey jersey in their band, there are going to be potential trademark issues. I know I'm throwing a lot of stuff out there, but these are things that are coming, and to start the process of maybe putting one new line into legislation so that when these things come to us, there'll be a place to go to fix them.
Isn't this bill discriminatory? So a Harvard student who happens to invent Facebook while he's a student and makes millions of dollars he doesn't have to worry about putting his face on the product, but a Harvard football player does.
Yes, I get you. The point is well taken, and I understand what you're saying, and again, this is sports centric.
I got it. All right. Okay. Before I let you go, and this is really for everybody in the room, the Commerce Committee has actually visited this type of issue already, and it was related to J.D. Salinger. And J.D. Salinger was very upset that he didn't want anybody to ever see his picture. And when he lived in
Cornish?
in Cornish, yeah. And the first scandal was that some guy was advertising that he had a toilet. He was a plumber, and he had his toilet. It was advertising it was J.D. Salinger's toilet, and he had it on Google or something, something. But the issue the bill came into is protection of people's identity. The bill was put in by his family. And oh my God, we got emails from every sports athlete all over the country, hockey, all of them. It turns out that the NFL can use people's image on their Madden because they have a contract with the Players Association. All right. So what this is really getting into is obviously this is college students, and that means the contract between the college and the student and getting that scholarship and that interrelationship, that contractual arrangement. So it's somewhat related. So we will do a little research on this. Was back in 2011, 2012 is when we had that bill. But at the end of the day, my memory was we killed the bill because basically we didn't want to get involved in this contractual arrangement, and that if the Supreme Court rules that college students can sell their picture and do it with anybody they want, then all the power to them.
I'm tracking, Mr. Chairman, but as I said, that there are things that are coming at us, and so we're trying to start to anticipate them and be proactive. And I'm sure Commerce Committee, whatever you do with this measure, will be enlightened. I'm sure.
Thank you. Thank you very much.
Thank you all.
All right, Chair, we'll call on Representative Pressa, who is in support of the bill.
Thank you, Mr. Chairman. My name is Adam Preza. I represent Hillsborough District 12. I am in support of this bill, with the exception of removing page 2, lines 20 through 23, section 4. That allows the institution and any athletic body governing that to use the athlete's name, image, likeness without compensating the athlete. The majority of athletes, especially in New Hampshire, don't get any NIL money. There's many D3 programs that don't have the exposure for it. And what you see is a lot of athletes on top of school athletics having to work a job to just pay their basic rent, food, everything else. And I think that takes away a lot from both the athletics and the academics portion. As a former Division III athlete and a current college coach, I think that if this was removed, it would allow the athletes to focus a lot more on those two subjects. Yeah, that's about it, actually. That's it.
Okay, and I'm going to play the devil's advocate. If we were not to pass this bill at all, would you be sad? Is there something in here that you really want us to pass?
Yeah. On page 1, line 23, the athlete needs to be have legal representation provided by attorneys. I think when this bill first passed, there were a lot of companies preying on some athletes. I can't remember the athlete's name, but last year, an athlete received a few $100,000, and in return, the company received 25% of that athlete's earnings for the next 20 years. I think that's unacceptable, because the athlete didn't have any representation, and he came from a poor family, and he just took the money because his family needed it. But now he's in this long contract where he's forced to give that company everything he earns for the next 2 decades. So I do think there should be some representation for the athlete.
Isn't that like an agent?
I think it should be legal representation. if this, that's the only thing that passed in this bill before it.
Right, but I mean, it doesn't, didn't he treat that company as an agent that they were going to promote him or?
Yeah, but the company was preying on the fact that he needed the money. And I feel like if he was represented by an attorney, he'd be able to negotiate a better offer.
Oh, he didn't have proper
Yeah, he had no representation. It was just him.
Okay, got it.
It says an institution shall not prevent. That is under all that section. So it's affirming what you want.
On page 1, yeah, Chairman asked if there was anything else for the bill. So I was just pointing out.
You were looking for the positive, right?
Yeah,
Okay.
yeah.
The positive is we would make sure that any student that did this, that they had proper representation and make sure
Yes.
they know what they're signing. Sounds fair enough to me. Okay. No questions from the committee members. Thank you very much. Have one more card left here. And it looks like, is this a tag team? Okay. Laura Banker and Allison Ridge.
Good morning, Mr. Chair, members of
morning.
the committee. For the record, my name is Lauren Banker. I serve as the Senior Director of Government Relations for the University System of New Hampshire. I'm joined by my colleague, Allison Rich, who's the Director of Athletics at the University of New Hampshire. We are here in opposition to HB 312. I just wanted to give a brief summary, and then I'm going to pass it along to my colleague to talk a little bit more about some technical concerns that we have with the legislation, as well as maybe some clarification on some of the questions that were asked earlier. So the University System of New Hampshire supports a student's right to profit from their name, image, and likeness, also known as NIL, and our campuses have policies in place to support students in their efforts to do so. We believe this bill is problematic given the ever-changing climate of NIL provisions on the national level, and we're strongly urging the legislature to avoid developing a patchwork system that could undermine our ability to attract and retain student athletes in New Hampshire. We're seeing a lot of demographic changes now. It's very competitive in the higher ed landscape, and anything we can do to keep athletes, keep student athletes, keep students, attract and retain them to stay in New Hampshire and go to our institutions is something that we really prioritize. And we have concerns with this legislation being able to undermine that. So I'll pass it along to my colleague who can speak a little bit more too.
Sure. Thank you very much for having me again. Excuse me. My name is Allison Rich. I'm the Director of Athletics at the University of New Hampshire. Just a brief overview, very brief. Name, image, and likeness. This was something that originally was not permitted by the NCAA. So if a student athlete wrote a book or created a product or wanted to be an influencer, he or she had to separate who they were as an athlete from their ability to profit. So they couldn't use their reputation as an athlete. This was something that was evolving over the years. The NCAA was looking at changing this so that student athletes could do everything that non-student athletes could do. The Alston case, just to clarify a little bit, that case regarded educational benefits. It was not related to name, image, and likeness, but it was right at the same time that name, image, and likeness rules were being created by the NCAA. So it gets confused quite a bit. So that precludes institutions from limiting the amount of educational benefits that are received by student athletes. So there's a cap right now of $5,980 a year that a student athlete can receive on top of their scholarship when their educational benefits.
How much was that? I'm sorry.
$5,980. I know it's really a strange number. Well, why not six? So the timing of that, when the Alston case was decided, there was some comments by the Department of Justice, the NCAA, saying you should be very careful about the regulations that you impose on anything regarding a student athlete's ability to earn money. So the name, image, and likeness rules by the NCAA were created permissible. So all student athletes at any level of NCAA school can participate in name, image, and likeness activities. That rule was passed in July of 2021. There are a number of states that do have NIL laws in place, and many of those were created in 2020 or 2021 before the NCAA rules were passed in an effort to protect students to say, if the NCAA prohibits you from participating in NIL, the state law will override that and say that you can. So many of these are somewhat moot. They're still in place. One has already been repealed. A few have been modified significantly to make them less and less stringent. So as the NIL has developed over the years, student athletes have been able to participate, and they do at UNH. We do have policies in place to protect the student athletes. We recommend that they reach out and connect with an advisor or an agent if they are entering into contracts. It's not required, but we do recommend that of them. We help them if they have questions on how to select that type of representation, and that is permissible. So this bill wouldn't change that. That is permissible for all student athletes to participate in right now. Right now, many of you probably know, the NCAA is in an interesting situation. We have an impending potential settlement of 3 antitrust cases known collectively as the House settlement. That, if it is approved finally by the judge, will go into effect. Will it be approved in the beginning of April? Will go into effect this summer. What that will do is it will change a little bit of the relationship, the dynamic of the relationship between schools and student athletes. So it will still maintain the NIL opportunities. It will allow schools to bring NIL in-house, so that if a donor would like to give money to a student athlete for their name, image, and likeness, actual work performed, that's something that will be in effect as well, that will be permitted. So there'll be a number of changes coming. There are also several bills in the in the Senate and in the House regarding name, image, and likeness and student athletes and their status as employees, hopefully not employees. And so there's a lot of things happening right now in this landscape. So we don't know exactly what it's going to look like. The bill, I recognized this bill because I was at Princeton University before this and was very familiar with the New Jersey bill, which was enacted but has not gone into effect yet because it was, again, as a preemptive measure and would be effective five academic years after it was enacted. And I think that was really to maintain, to ensure that NCAA rules were changed, student athletes were protected, all of that. I haven't heard a lot right now about it going into effect, but I think if all of this changes with the House case, you will see that that bill or that law will probably go away because it's not necessary anymore. So there was a time when these laws were important because we wanted to make sure students had the ability to capitalize on their name, image, and likeness. Right now, we're kind of moving in the other direction because all schools are permitting this. Students have a great opportunity to make money on their name, image, and likeness, and they have a lot more autonomy than ever before. At UNH, we use this as an opportunity to provide them additional education. We provide them financial education. We talk to them about contracts. We help them with how do you look for meaningful and real opportunities as opposed to somebody that might come and take advantage. So there's a lot more information that student athletes have. So for us, it's been a great opportunity to talk about these things and help our student athletes with that type of education that will help them in the rest of their lives, whether they ever enter into an NIL deal or not. And they also have opportunities. We have jersey sales where they're profiting on the sale of their name on those jerseys. Some of them are representing local companies, and we'll continue to do so. And we're going to do everything we can to support them in their abilities to be able to capitalize on that. So this bill would be a little more restrictive potentially than what's happening. It would not permit the schools to be involved in the process. With right now, we are permitted to not enter into deals with student athletes, but to connect. So we have sponsors that we've linked with our student athletes who are hiring them to do this legitimate work. Other companies, alums, things like that. That would be something that we would not be permitted to do if this bill were to pass. And eventually, we'd like to be able to do some in-house, which would allow our donors to give directly to the school to be given to the student athletes. So There are protections in place for student athletes. There's also nothing in this bill that's relative to international student athletes. And international student athletes right now, based on federal law, are not permitted to earn money for their NIL in this country. They can do it in their home countries. So again, want to make sure that those student athletes are protected as well. So right now, I think we're in a really good spot. We've been managing NIL and expanding the opportunities for our student athletes. We're staying on top of every change nationally, federally, with the NCAA, and we'll continue to do so. And I think we're able to do that and really provide a great experience for our student athletes, recruit and retain outstanding student athletes instead of them potentially going elsewhere where it's a little easier for them to capitalize on the NIL. We want it to be a great experience. Once they get to our school, they love it. They stay. Many of them move to New Hampshire and stay here as adults and live their lives here and business. So we love contributing to the state that way. Our student athletes love it at UNH. We just want to make sure that we have the ability to bring them here and to retain them with all the opportunities that student athletes have in other states. So I'll be happy to answer any questions.
I think we're all set. Thank you very much.
Thank you very much.
Thank you.
Having no more cards, we'll close the public hearing on 312 and running late. Yep. Blue sheet. Yep. Blue sheet is Representative Heath Howard was in support. Okay. Next up is 427. Okay. We'll open up the public hearing on House Bill 427 and hear from the prime sponsor. Good morning, Representative Bernardi.
Good morning, Chairman Hunt and committee. For the record, I'm Representative J.D. Bernardi, Rockingham 36, Southampton, Newton Plastow, Hampton Falls, and Kensington. I'm here to introduce House Bill 427, which is amending the UCC. It really deals with two subjects. Predominant portion is ownership of securities, and I also have a section on deposit accounts. I provided you a handout so you can follow along as I'm speaking here, and I also provided the testimony of Attorney Don Grandy, who more eloquently, legally explains the issue. So what is the Uniform Commercial Code? It's the commercial Bible. It has a goal of substantial uniformity of rules for business transactions, excluding real property that will facilitate commerce. Individual states can adopt or reject proposals to suit local needs. Adoption is generally uniform, but not universally so. Proposals are generated by the American Law Institute and the National Conference of Commissioners of the Uniform State Laws. New Hampshire has representation along with all the other states. So the first section I'd like to speak about is Section 5 of the bill, simple provision. It addresses RSA 382A9-102A29. It disallows programmable medium of exchange as an identified deposit account. So what is this doing? It's essentially prohibiting central bank digital currency. Central bank digital currency can more readily be understood as monetary coupons. The issuer, since it's a coupon, can control the time and place of use, create quotas for usage of that quote-unquote currency, and cause it to expire at will. This is a fantastic deal if you're a government issuer and you want to control people, control commerce, or use the excuse to control inflation. It's a horrible deal for we the people. I encourage your adoption of Section 5. The remainder of the bill deals with the ownership of securities, both yesterday and today. When we buy stock now, and I'm on this page, the money follows the path from you as the investor to the brokerage and eventually to the banks and what is known as a depository trust clearance corporation. In the 1990s, on the next page, the UCC was amended, and that amendment many have dubbed the Armageddon Plan. So what we're doing is, rather than purchasing stock now, we're purchasing security entitlements. They become part of a large, anonymized, de-identified stock pool held by the DTCC. The pool can be used as collateral by the custodian of the DTCC. Note, we could have adopted tracing, so your ownership could be tracked into that pool. That has not been done. The ramifications of this really appear when there is a financial crisis, a liquidity crisis. The UCC's provisions that we're amending provide that the too big to fail banks, JP Morgan, Wells Fargo, Bank of America, Chase Manhattan, that crowd, have priority to your investments because they've now been de-identified from you if the assets are needed to pay the debts of the broker or insolvency of the custodian. You get to sue for the crumbs. It's that simple. HB 427 reestablishes ownership of people's securities and money. Now, we are not the only state looking at this. Many have said or proposed that, oh, go back to the UCC Commission, have them make an amendment, send it through the process. They did this, and they did this on purpose. There are other states that are not waiting for us to go that route. 13 have already proposed legislation. 3 more are working on drafts. I present to you one other code that offers more universal guidance. Thou shalt not steal. With that, I encourage passage of HB 427, and I again refer you to Don Grandy's more legalistic testimony. And I will also note that David Webb is here from Sweden. He is the author of the book, The Great Taking. He has in deep knowledge of this entire process and how these rules came into being, and would be more than willing to answer all your questions. And I will
Yeah,
take
I have
initial
his
questions.
card, but this other person, Don, I don't have his.
No,
card.
he's not here. You just have his testimony.
Okay. Oh, the testimony that I got. Okay, great. All right. Any
Thank you.
questions on the committee members? Representative Gibbs.
Thank you, Mr. Chair, and thank you for coming in this morning to testify. I have 2 questions. The first is, what is the DTCC?
If you look at the slide on how you're buying stock, Depository Trust and Clearance Corporation.
I'm sorry?
Depository Trust and Clearance Corporation.
Thank you.
It's where all these stocks get anonymized, de-identified, and put into a big pool that can be used as collateral by the custodian.
Thank you. And the second question is, when I read this bill last night, I understood programmable medium of exchange to apply to all types of cryptocurrency, not just currency issued by the government. Why wouldn't it apply to all types of cryptocurrency?
I don't believe cryptocurrency is considered a deposit account, and this is amending the language of deposit account.
Well, no. It says it does not include a programmable medium of exchange. Okay? And you've said that the programmable medium of exchange would only be government issued cryptocurrency. And my question is, why doesn't that include all cryptocurrency?
Again, the only thing I can say is the language in Section 5 is amending the definition of a deposit account. So I don't think cryptocurrency is currently considered that. Potentially, Representative Ammon is in a better position to answer that than I am. Yeah.
Definition probably needs to be cleared, and yeah, because yes, the crypto is a commodity, whereas we are talking about fiduciary,
Exactly.
money. We're talking about
Money. We're talking about
Oh,
money.
and what is the fiduciary? What is it?
Yes.
Finza. So
FINZA
versus-
stuff,
right,
yes.
So that is the difference. So, but yes, probably. So is this model legislation, or where would you have gotten this language? Where did this come from?
It is model legislation that several of the other states are also pursuing.
Yeah.
Yes.
So just the general assumption is that in terms of what a deposit account means, and I would say when I first arrived here on this committee, deposit account always meant a cash checking account. It's cash. It had a monetary value. So I think that what happened is that the nature of this legislation was that they wanted to add this programmable medium of exchange into it, so that and to clarify what it can or can't be.
But what it says is the term, presumably the term deposit account, does not include a programmable medium of exchange.
Right. So it means can't be Bitcoin.
So it can't be cryptocurrency,
Right.
any type of cryptocurrency.
Can't be any cryptocurrency because that's a commodity. Anyways. Okay. Representative Spear.
Right now, of all the, about 160 some odd countries looked into central bank digital currency. Only 15% went ahead with it. The United States has has bills currently before both the Senate and the House to forbid it. The Federal Reserve says they are not interested in it and don't want any part of it. Why do we think we need a law to prohibit something that no one wants to do?
Well, the European Union just created a digital wallet. What do you put in a digital wallet?
Euros.
Or programmable currencies. So it is a preventative measure. We changed the administration again, and we may have an entirely different point of view. So this is protective.
Further? Thank you. Okay. Thank you very much.
Thank you.
Okay. So David Webb. All the way from Sweden.
Yeah.
Okay.
Thank you for the opportunity to speak with you. Thank you for the opportunity to speak with you. I'm grateful. Let me begin by saying for 4 centuries, securities were personal property. Now, what that meant was in the event of insolvency in the financial system, you, the public, were absolutely bulletproof because it was your property, your personal property. That's why they were called securities. Now, what that meant was if your intermediary failed, you could say, I'm sorry, you're out of business. Here's where you deliver my stuff. That has been subverted. Now, how do we know that? It's plain as day. You cannot revindicate means to take back your own securities out of the insolvency of a financial intermediary. You are no longer able to do that. Now, how do we know that? We know that because when Europe was being pressured to conform to this U.S. model, they formed something called the Legal Certainty Group to investigate how to do it. Now, what they meant by legal certainty is legal certainty that the secured creditors keep the assets. That's what they meant by legal certainty. Finality, certainty of finality. So what they have done is to shift this certainty from the public being absolutely bulletproof in the event of catastrophic failure to the secured creditors being absolutely bulletproof in a catastrophic failure. It's a shift of this legal certainty. So how do we know this? The Legal Certainty Group sent a detailed questionnaire to the New York Fed. The New York Fed is the Fed. This is the business end of the Fed. And attorneys for the Fed responded to that questionnaire in March of 2006. They specifically state that they are commenting on the operation of UCC Article 8 and portions of Article 9. So we have a definitive primary source document directly from the top of the financial system. This document will not be acknowledged by anyone you will hear from the Uniform Law Commission. It will not be acknowledged by the Securities Industry Financial Market Association. They don't seem to know that this document exists. The Fed makes clear that securities are held in pooled form. You do not have the right to revindicate the securities out of insolvency. In the event of insolvency, the investor is always vulnerable. Further, that, and they put this in quotations, segregation, segregated accounts, that has no effect. Now, how is this being done? Your relationship is with a lower level intermediary in the system. You're a brokerage firm or a custodian. You have a contract with them, but the property is actually held at a higher level in the system, and you have no relationship with that entity that is holding the property. And once securities enter a chain of use as collateral, they are reused many times over. These chains of collateral use and reuse, hypothecation and rehypothecation of securities are very, very long now. So what enabled this was the amendments to the Uniform Commercial Code in 1994. So this Federal Reserve document speaks specifically to this. Another very important document is something called Policy Perspectives that was published in the UCLA Law Review in 1996. That is a detailed historical discussion of this by James S. Rogers, who was the drafter. He wrote the changes to the UCC. He talks about this being done for Armageddon planning. This isn't other people saying this. This is the drafter. So the intent, this was not about modernizing the system, making it more convenient, more efficient. This was about ensuring that certainty was shifted to the secured creditors in the event of financial failure. Another very important thing to understand is the failure of Lehman Brothers in the last financial crisis, 2008, 2009. The people that say there's nothing to be done here will say, well, no one lost any money in the failure of Lehman Brothers. The important thing to understand is that all client accounts were frozen the moment that bankruptcy was filed. So retail accounts were sold. The clients weren't able to take their money back out of their accounts in the teeth of a crisis. It took some weeks and months for those accounts to be sold, and then they could have access to them again. But the bigger thing that happened here is many sophisticated institutional clients, unbeknownst to them, their treasury securities, their collateral, was being used by Lehman Brothers under swap contracts to arrange financing for Lehman Brothers, which is common practice. There was nothing unusual about that. And as long as the music doesn't stop, those clients would never know that their securities were being used. But the music stopped. Now, this is the very interesting thing. JP Morgan was the custodian for client assets. JP Morgan was also the secured creditor that took the client assets. Now imagine this is in the teeth of a terrible financial collapse. Those firms relied on that collateral to be able to operate. So 5 years later, there was a bankruptcy court decision in the Southern District Court of Manhattan. What was happening there was these sophisticated clients, these are the big boys, you would think wouldn't run afoul of something like this. They were suing 5 years later, still trying to recover their collateral. And the bankruptcy court, the judge found that JP Morgan was entitled to take their assets. The only consideration was whether JP Morgan was in the protected class to be able to take these assets. And that's basically the largest financial institutions have this super priority to keep the assets in a collapse. And they need that because there are so many claimants. The securities are now used so many times over. So this is a real issue. There's another document, a Bank for International Settlements document from 2014 about the collateral management system that we now have globally. And there's a chart in this showing the flow of collateral from collateral givers to collateral takers. Collateral givers are everything: equity trading desks, bond desks, custodians globally. That flows through a collateral management system that operates particularly in a time of crisis when the value of the collateral is falling. So there will be more and more calls for more collateral. Where that is going, the destination, the collateral takers are the central clearing counterparties that house the derivatives complex. This is where the collateral is being used. Now, when they made this change in 1994 to allow the use of these pooled assets legally, they were doing it illegally prior to this. They had to paper it over. There's no coincidence that is when the derivatives complex began exploding. So in 2001, it was about $110 trillion. By 2007, it was 700 trillion, 10 times global GDP. It's estimated that now it may be 20 times global GDP. This is where the collateral is being used. And ultimately, that's where it will be taken behind these contracts. So when we own the property as certificates, we had certainty. Now we have something that functions like a contract, this idea of a securities entitlement. That is very weak in the event of insolvency. But at the other end of the food chain, certainty has been given to contracts, these derivative contracts, but only for the biggest banks that are behind those contracts. And this is the Armageddon planning. Now, how do we face up to this? How do we understand it? In the UCC, you will see the statements that the entitlement holder has priority over the secured creditor of the intermediary. And that is the statement that was promulgated to sell the amendments to the UCC in 1994. What they neglected to show was there were two exceptions to that. And that's what this bill does, is simply and elegantly removing those exceptions under which the collateral, leaves the barn. The barn door is open and the collateral is out. So by striking these exceptions, you then just have language that the entitlement holders have priority to their own assets. These exceptions, there are two that we have to remove. The first is that if the secured creditor of the intermediary has control, the secured creditor has priority. Control is a concept from bankruptcy law, which means just the ability to act upon the asset. Now, what we know with paper certificates, it was clear who had control. By dematerializing, it becomes unclear who has control. But what you know is the control always resides elsewhere at a higher level in the system. The second exception is that if the secured creditor is a creditor of a clearing entity, that secured creditor always has priority. Clearing entities are basically any broker, a clearing firm. It's Lehman Brothers, it's Goldman Sachs, and it is certainly Depository Trust and Clearing Corporation. So I've probably said enough for now. I'm sure you have a lot of concerns and questions, and I'm available now and later.
So you're not in Stockholm? You'll be here for our subcommittee?
When will that be?
I don't know. How long are you here stateside?
I just came over to do this, actually.
Okay.
Yeah.
Yeah, we wouldn't, the subcommittee would be, that can't even be next week. It would have to be the week after.
Okay. It's possible.
Okay.
It's possible I can come back. Absolutely.
That would be great.
Just a quick question.
Representative Sullivan's hand I saw first.
Okay.
Thank you, Mr. Chair, and thank you for taking my question, and thanks for coming in from Stockholm. So just to make sure I understand what's going on here, so I use Charles Schwab as my brokerage. I buy some stock in Dollar General. Just bought that this week, that's why I say that. But so I buy that, and then you're saying, Charles, I don't technically own it. Like we think I do. I think I do, but I don't technically own it. The way you're describing it to me, it gets sent to perhaps another bank or maybe Charles Schwab itself to use as collateral to run other sort of security type arrangements, derivatives, whatever. Is that what you're telling me?
Yeah, what you have, you'll hear this term beneficial ownership. That is a term, you'll see it in some of your documents. Beneficial ownership is a term that arose coincident with these changes in '94. Beneficial ownership is basically an appearance of ownership. They make it appear that you own it because you can vote the shares, you can buy and sell them. It works like ownership in every case except insolvency. That's the Armageddon planning. So what happens is literally all securities are pooled at Depository Trust Clearing Corp. This houses the entire securities complex of the United States and much of the world. It's all there. So any individual broker is a clearing member of Depository Trust and essentially has an account at Depository Trust where all of the client's securities are pooled there with no specific identification of any person, any security. So, and that's how they're able to use those securities for the firm's purposes. Now, James Rogers, in this document, Policy Perspectives, he says, what do securities firms do? They sell securities. And the party that has bought that security has no idea whether they did that wrongly. They don't know whose security it was. They are entitled to finality of settlement. What do securities firms do? They borrow money using securities. They do that under swap contracts. So who the party on the other side of that contract, they can't know whose securities were being used. So he also explains in this document that when they were coming up with this approach, many attorneys were uncomfortable with the idea that the securities could be used wrongfully. And he said after careful consideration, they eventually agreed. As I say, they got more expensive attorneys. So they eventually agreed that the securities can be used wrongfully. The Fed's response to the legal certainty group says that even fault, fraud, and negligence does not prevent the secured creditor from taking the securities. So this is a reality. If you're in the securities system, you just have an appearance of ownership as a direct answer to what you're saying. It's important to understand this is not just small investors. This is important for states. This is the pension plans of the state. This is the finances of the state. Another important thing to understand is the tiny interests that benefit from this, that run the banking system really at the highest level. They want people in the financial services industry to think we're all on the same side in this. We're protecting you. Actually, the people in financial services, let's say in the state, they are at the bottom of the food chain. They are the intermediaries that will incur the wrath of their clients. They will, when their assets are lost, the financial services firms in this state do not have the assets. The assets are held at a higher level.
Really? Okay.
So if we were to, presumably one of the biggest, I mean, there's probably a lot of arguments for the current system we have. I'm assuming the biggest one is probably liquidity. You know, are we gonna, if you lock up things that they can't be used as collateral? I'm not saying that we should be using things as collateral
Yes.
without the permission of the perceived owner, but presumably this could really drain liquidity from the
Yes.
system. Is that not a potential concern? I imagine maybe the people behind you will bring that up.
They will say this, and let me say that the reason I went to Sweden in 2009 was that I discovered this then, and Sweden and Finland were the only countries that had not been subverted in this way. All the G30 countries had been pushed to dematerialize in this way beginning in 1970, but the way the Swedes did it, so they had a modern indirect holding system, but they used computers which existed to have specific identification of every person to every security. And by going there, I was actually able to move my Swedish government bonds from here, there, and really own them there. So it's not true that you can't have a modern, efficient system that is entirely electronic, but the way it was done here was to sever this direct record and create this pooled nature. The other thing is, by just striking these exceptions, none of the plumbing changes. This is why this is actually a very conservative approach. It's an elegant conservative approach because nothing will change in how the system operates. It will only come into play if there is insolvency, in which case you want to have made these changes.
Thank you.
Okay. You still have a question or?
I think I can get the answer by looking at the video.
Okay. All right. So my question is really simple. It says in here, banks that are too big to fail. Right? Banks that are too big to fail. And now you're talking about Armageddon. So are you saying that Armageddon, this is a yes no answer. Are you saying the Armageddon is the bank that was too big to fail? The Armageddon is that it did fail? That's what we're fearful of? That's yes no? Is that what you're trying to say to us?
I'm not sure.
What
how
is
to
the
answer that.
Armageddon? What is the Armageddon?
the-
The Armageddon is the banks that are too big to fail, right?
The Armageddon planning is that the assets will be taken by the biggest banks.
Great. Okay. Representative Burrows.
Thank you, and thank you for taking my question. Just a quick question. I missed who you represent and why you came all the way
Well,
from Sweden.
I represent myself. I don't represent any entity. This is my work. This is what I do. And I don't, whatever comes from this book goes to support Don Grandy's efforts, who wrote the bill. So this is entirely because I care about what's going to happen here to all of us.
Representative Gibbs.
Thank you, Mr. Chair. I'm confused by something. Early on in your testimony, you said that nobody lost money under the current system with the Lehman Brothers failure. But then later on in your testimony, you said that J.P. Morgan was allowed by a court to take
Yes.
investors' collateral because
Yes.
J.P. Morgan was a creditor, in which case the investors would have lost money. So which is correct?
Yes, it's I made the first statement because that's what the bank lobbyists will say, is that, and they have, that no one lost money in Lehman Brothers. This is an analogy for this. Let's say you come out of your home in the morning, you need to go to work, and your car is gone. And 5 years later, your car is returned by the police. Does that mean your car was not stolen? Obviously not. That's what happened with, I'm agreeing with you, that's what happened to these very sophisticated, enormously powerful investors, investment firms. They lost the use of their collateral when they most needed it, and for over 5 years.
Follow-up question, please.
Further question?
Thank you. So is what you're saying that eventually they lost their collateral or eventually they got it back, but there was a long judicial process?
Well, it was possible to make recovery because another even bigger financial bubble was blown up that allowed that to happen. So they did eventually make recovery, but that's the purpose of that car analogy. The car is still stolen. The property was stolen when they needed it most. They may have gone out of business in the interim, those firms, to have lost their capital in that crisis. They might not have even existed 5 years later. So does that help to answer the question?
That's great. Thank you.
I'm sorry. One more follow-up.
Okay.
Thank you. So did any company go out of business as a result?
I don't know, actually. I think there were a lot of firms who went out of business, but I don't know about specific firms that had their collateral taken. But well, I won't go into a story
Fair
about
enough.
that.
Thank you very much. All right.
Okay.
So we'll I'm sure JD will make sure you know when our subcommittee's been scheduled.
Okay.
Thank you. Okay. For the other side of the story, Charles Mooney for the Uniform Law Commission.
Thank you, Chair. Good morning, committee. My name is Charles Mooney. Last year, I was appointed by Governor Sununu as a Uniform Law Commissioner for the state of New Hampshire. Amendments similar to HB 427 were presented to several states last year. None of them passed, and I think the same result should happen in New Hampshire. You've heard Mr. Webb. You know, I don't know whether to say I don't know what to say or I have too much to say. But I will say, and I choose these words carefully, virtually every statement he made about the operation and characterization of UCC Article 8 was wrong. And I've never been involved in a debate where we didn't debate based on policy disagreements and arguments about instrumental effects of the law and the like. And I'm very sad to have to make that, and I can't dispute all of them. But what I would like to do as a first step, and the chair has mentioned the subcommittee, and there's an opportunity for us really to roll up our sleeves and get to the nitty gritty. But what I would like to do today is a bit of education and description. This is inspired by the book that was mentioned, The Great Taken. It's a classic conspiracy theory. I won't take my time, but I really hope I get a question about that, because I would love to explain how it just doesn't work. So let me talk a little about the background and the intermediated holding system for securities. I've distributed a handout. Exhibit A is just a diagram of the holding system in the United States and many other countries. Depository trust company, securities depository is at the top. Banks and brokers have accounts with it. And those participants who have accounts have their customers who are investors. Some of their customers are other intermediaries going down the chain. This has been a common means for investors to hold their securities for many, many years. There's nothing new here. What has been new is that since the 1960s, the infrastructure has evolved because there was a near breakdown in the securities markets because of so-called paperwork crunch. They couldn't keep up with the trades. So now at the top, the participants for every trading day, all the trades are netted out so that every participant either delivers or receives one amount for each security and either pays or receives payment of one amount for all the trades. And this intermediated holding allows that in the operation of DTC, which has evolved over the years from starting out as an arm of the New York Stock Exchange. So HB 427 is a proposal to amend Article 8. This is a solution in search of a problem. It's an unwise fix for a non-existing problem that would only harm investors, both individuals and businesses. Article 8 deals with transactions in investment securities. It promotes uniformity and efficiency and predictability across state lines. Customers do have a property interest. And let's set one thing straight. This security entitlement that Mr. Webb has described is everything that investors, customers of intermediaries had before these 1994 amendments. The idea that it was created by them, the term was created, but the security entitlement simply describes what it is that the investor gets: a property right, a proportionate property right, and all of the securities of a particular type with all other investors who have accounts with that intermediary, and a bundle of rights and duties against the intermediary, which is something that was not spelled out in previous law. There's also more protection for the property rights than there was under the previous version of the Article 8 of the UCC, and I'm, again, prepared to explain in detail how that is, but you're getting the idea this is complex. I'll do what I can in the brief time I have. An intermediary can only pledge these securities if customers have an interest in them, subject to very stringent requirements, only with the consent of the customer. Nobody takes them. Customers exercise their right over their property interest to transfer them. These proportionate property interests, these pools of securities, have existed for a long, long time, long before the UCC even, which began work in the 40s and first promulgated in the 1950s. So the proposal is to take 8511, which starts out with the baseline rule is a customer has priority over a secured creditor of the intermediary. That's Exhibit B. You can see intermediaries borrow. And that was something added in the 1994 amendments. It did not exist before then. Then there are two exceptions. One is if there's a loan to the intermediary, that's where the lender takes control, that is the power over the asset, actually essentially takes it away. And the other is a loan to a clearing corporation like the Depository Trust Company. The DTC and its affiliates have billions of dollars in backup lines of credit that would be jeopardized or eliminated if these were to pass. These lines of credit back up the settlement process if some intermediary fails to make sure everything gets performed in time. And it also provides substantial protection against systemic risk. Now, the suggestion was that the 1994 amendments added these priorities. Well, they added those provisions, all right, but there are corresponding provisions which provide additional protection for the investors. Consider first a bank that borrows. Banks normally don't use customer securities to borrow. Only brokers are allowed to do that, and that to a very, very limited extent. In no bank insolvency I'm ever aware of has any customer lost where the bank was the custodian. It's simply a non-issue. Although banks do sometimes borrow with securities, a secured lender, this is asset-based. In the securities market, they have to be sure they're first. And to tell them they might be subordinate down the line in insolvency to a customer, which is the only time collateral matters, is not much solace. But take where most of us have our securities with broker-dealers registered with the SEC, members of the Securities Investor Protection Corporation, which provides certain protections in the event the broker is in an insolvency proceeding. What's the priority there? Well, the priority is that secured creditors have the priority. The UCC doesn't apply. SIPA, the Securities Investor Protection Act, provides that priority for these broker-dealers. There are some other problems that will be caused, I'll mention, however, but this certainly wasn't anything that was brought about by the 1994 amendments. Why is that priority there? It's there to benefit the investors, the customers of the broker. In Exhibit 2, you can see the loan to the intermediary. Customers often want to borrow from their broker. These are often called margin loans. Now, the proponents have suggested elsewhere that, oh, that has nothing to do with this. These priority rules are loans to the intermediary, not to the customer. Well, a broker-dealer is not like the old Scrooge McDuck sitting in a room full of coins and bills with money deciding what to do. Broker-dealers have to fund their loans. They borrow at favorable rates, which allows them to loan at favorable rates to their customers. That's the only reason we have that priority, other than the fact it's been the priority that existed even before SIPA in the 1970s going back at least to the 1930s when the Securities Acts were enacted and changes to the bankruptcy law were made. So this priority has always been there. The idea that until 1994, as indicated, for 400 years, I don't know where that number came from, but I've only been researching in this area for about 52 years, maybe 53. But the idea that somehow before then there was some rock solid interest in a specific security is just ridiculous. That hasn't been the way intermediaries held customer accounts forever that I know of. Well, maybe they used to actually have custody of those things like a safe deposit box, but certainly not in the modern era. The only time a customer would have a right in a specific security is if it's actually in the name of the security, written on the certificate. Usually that happens when the broker-dealer fails, and a few times they have, and they were getting ready to mail it out to the customer, but it's still in the mailroom or still in the desk. So the idea that somehow before 1994 or going way back, you had some different kind of property right is just wrong. I mean, the reference to the New York Fed letter, the idea that someone's hiding that. Well, nobody's going to hide something that's harmless. I mean, it's essentially laughable. All that said was, in answer to a question, does an investor, a customer, have a property right in any specific security? Well, the Depository Trust Company has warehouses, some of which are in New Jersey, which was mentioned in one of the earlier hearings. Certificates are everywhere. Customer names are not on those. And of course, the answer was no. They have a proportionate property interest in the securities of that type, not in any particular security. All the customers would share. Not only that, for broker dealers, if I've got a security interest and I'm a customer, if I've got a security entitlement to ABC shares, and the chair has a security entitlement to XYZ shares, and the broker fails, and there are plenty of ABC shares, but the XYZ shares are gone, is the chair out of luck through the pure fortuity that there's a shortfall here and not there? No, the chair is not out of luck, because under the Securities Investor Protection Corporation, all of the customers of the intermediary, the failed broker-dealer, share in the entire group of all types of securities. And they take their net equity, the value they're supposed to have in their account, less the amount they've borrowed from the broker, and that's their claim. And they have that claim to all of the securities, not just to the ones. So even if the private law, UCC, provides that you have a property interest in specific things, that would apply in a bank insolvency or for a clearing corporation. But for a broker-dealer under SIPA, all the customers share. This ensures that customers have a much, much, much lower chance of a big loss. And of course, under SIPA, SIPC provides protection for investors and broker-dealers, for the retail investors, up to $500,000 in loss. Now, that's not $500,000 in securities. That's loss. If I've got $5 million in securities in the account, and there's a highly unusual loss of 10% of the customer securities are gone, well, I'm still fully protected because my shortfall is $500,000. That's loss. I'm happy to provide data, and we could get into this in the subcommittee meeting, on the experience of SIPC, the claim that it's underfunded and couldn't meet its obligations is unfounded, and I think we can explain why losses have been relatively minimal. There have been relatively very few broker-dealer insolvencies. Finally, I should mention on these protections in Exhibits B and C, when a broker borrows from a lender and uses customer securities, which are securities it's allowed to use because customers have consented, there are a couple of important restrictions. One is the borrowings by the broker for customer securities cannot exceed the amount that the broker has loaned to its customers. So they always offset. So the customers can never lose more from the bank's borrowings than the customers as a group would lose based on what they actually owe, because the bank can't borrow more than the customers owe. Secondly, as in Exhibit C, there's a reserve account. When a bank borrows using these securities, the customer has agreed, not all of the customers, only a fraction can be used by the broker. When the broker borrows using that collateral, it has to take what it borrows and put it in a reserve bank account. Now, it can offset that, in effect, take it out of the account, the amount it has loaned to the customer. So it's borrowed 100, it's loaned 100, it doesn't have to post anything. But if it borrows 120 and is only loaned 100 to the customer, it has to put 20 in cash equivalents to the reserve account. Well, that wouldn't make much sense to borrow at market rates and then somehow have to invest it in a sterile reserve account. What this ensures is that the borrowings by the brokers, in effect, must be used for the benefit of the customers to fund these loans. Well, in some, the system works well. Investors are protected. There's simply no need for these amendments. They wouldn't serve any useful purpose. They could only disadvantage both investors and the markets. I will say that if New Hampshire passed these amendments, in my view, I'm not the bank lobby, but I've been involved in credit for my entire professional career and even before. I think it highly unlikely that there would be loans to banks located in New Hampshire, except at a much higher cost if they were made. For brokers, even though SIPA provides that secured creditors have priority, I would predict substantial litigation and risk for banks that bank lenders they would see if these passed in a state, and much less if they started passing in more states, because there would be litigation. Why? Well, we've never had this big disparity. Assuming this amendment were to pass, we would never have had this big disparity between the rules for the insolvency rule under SIPA and the private law rules. So I can imagine folks, trying to argue, oh, well, the private law overrides. We now have to change it in accordance with these new amendments to the UCC. So I can't go into detail now, but I'm happy to answer any questions or provide any additional detail. I think my professor persona got away from me, but this truly is an educational opportunity because this is a complex subject, but an important one. So any questions you have, I would be happy to.
I hope we can hold it to the subcommittee. And Representative Walsh has a question.
Thank you, Mr. Chair. I'll be brief, and thank you for taking my question. Pardon my, lack of financial prowess in all this. I realize it's very deep, and you somewhat touched upon this, but we are Commerce and Consumer Affairs. So if the proposed legislation protects a consumer and if you've already got a wall with this SIPA, wouldn't this just make that wall a little bit thicker? I guess I don't understand what the major objection is. If you could
Well-
just simplify for my tiny mind a little bit better.
The objection is the ability to get, for my broker to get credit is a big advantage for me if I want to make loans. And the broker can only pledge only where consumers and investors have margin accounts. They've agreed that they can borrow, and they've agreed that the broker can use their securities, only a portion of them, as collateral. And to tell me my broker now is going to pay more for credit is not going to help me. Plus, as I explained through the customer protection rule of the SEC, both prongs of it, consumers are protected when their assets are pledged. It's not just a naked pledge. So that, I think, is the answer. Second, this has been the lay of the land for decades and decades. It has not caused a problem. There is no risk caused by that. The Lehman example, that didn't involve Article 8 in any way. All the retail investors were protected. The only reason some institutional investors waited 5 years is something they now recognize, and they're much more careful. But they had entered into so many transactions of such complexity, and almost every one involved lawsuits of valuing collateral, that the complexity of their transactions took that long to litigate. In any event, they might have lost more. If it didn't take so long, they might not have. But I think they know what they're doing. But I hope that's an answer. Just making it more costly for firms to borrow is not any help to securities account holders.
Hey, Representative Priscelli.
Thank you for your expertise and for taking my question. So this is just agree, disagree, and then we could get into it at a subsequent time. But do you agree or disagree with the provision that would disallow a programmable medium of exchange, essentially prohibiting a CBDC as stated in the bill? Agree, disagree with that provision?
I agree with its purpose. I think it needs some drafting, but I agree with the stated purpose to exclude the CBDCs. If that's
Yay,
if
we
that's
got one.
responsible.
Thank you.
Responsive. Okay.
Good.
Great. Thank you very much. We'll see you soon. Enough. As always happens, if I wait long enough, another card will appear. Next. From the Business and Industry Association in opposition to the bill.
Thank you, Mr. Chair. I will take up hopefully less than a minute of your time. Nate Grays with the Business and Industry Association. I won't repeat anything that was already said. I just want to note our opposition to state changes to the UCC. We think a more appropriate venue is to go to the UCC panel and get them to make changes and bring that back to the legislature. The point of the UCC, of course, is to provide uniform regulations for businesses across as much of the United States as possible. That ensures that for a small state like us, we have a competitive advantage because we know what the regulations are and businesses know what to expect. So on this issue and any other one, we would object to changes at the state level. Happy to take any questions if there are any.
Fair enough. Thank you very much.
Thank you.
And with that, I will close the hearing on 427 and if you want to, you have a handout, just pass it out. They used to say the Bankers Association is in opposition to the bill. And with that, you certainly will be there for the subcommittee no matter what. So, okay. All right, Tom. You're on. We'll open the public hearing on House Bill 406. I see our deputy. Is he? What's that? Oh, okay. You want to introduce it? Okay. No, see, this case, it's a department bill. I just assume have the department introduce the bill. Cut to the chase. And the deputy's here. We are now on 406. I apologize for the delay, but I'm sure you guys found that conversation very stimulating.
Good morning, everyone. My name is Erin Hennessy. I am the Deputy Secretary of State, and with me is Tom Connolly, who is the Director of our Corporations Division. We had many requests from several businesses in the state for this type of legislation to assist them, and I'm going to have Tom go into details behind that. So I would say, yes, it was a request of our office, but at the request of people who file business filings with our office.
Thank you and good morning. The bill that we have before you today is an attempt to address two specific problems, issues that we're facing here with the business registry that are not, unfortunately, they're not unique to New Hampshire. The first is company hijacking, situations where someone will go in and file an annual report, changing the names of the business owners, the business officers and directors, to make it appear as though they are in charge. And therefore, they can go to the bank takes a look at our records and say, oh, this person is the president or they're not manager of that LLC. And we'll use that public filing as a means to take ownership, to gain control of either business accounts or to apply for loans. We had a situation with a business who had an annual report was filed for that entity changing the name of the officers. The individual involved applied for a car loan, purchased a truck, and the business only found out that they owned this truck when they got the payment book in the mail 30 days later. What we're trying to do is when a business it becomes aware that an authorized filing has been submitted, to give us the tools to be able to verify that record was indeed authorized, and to be able to remove it from the public record as soon as possible if we receive a sworn statement from that business. The second issue we're dealing with, which is another one that's becoming more frequent, is what we call synthetic entities. Businesses that are set up to they appear as though they are a legitimate business or an existing business by establishing a similar name, using that same business street address and so forth. But in reality, that business is a separate legal entity that doesn't exist. And as a result of that, are trying to basically trade on the existing businesses attributes, its location. It may fool other folks into thinking that they are actually, for example, sending a check or obtaining an order from a legitimate business, when in reality that that business is not a legitimate entity. We've had a couple of situations here recently in New Hampshire. Representative Luz Bay, who's kind of put her as a primary sponsor of the bill here, had a situation with a constituent in Dover who owned a restaurant, and then a business was established with a very similar name using that same business address. They became aware of the issue when they received in their mail a bank statement from Chase Bank showing that a bank account had been opened up in that name, and then subsequently started to receive debit cards and other effects that someone was trading under that name using their address. The folks filed a report with the police department as a potential situation with business entity theft, but in reality, you see, there's not a lot that law enforcement can do in these situations. We were able to trace the transactions based on these entities were filed electronically. They were created using our website to go ahead and complete an LLC formation, submit it to us, make payment, and receive authorization that the filing had been completed. We traced it back to a IP address in Brooklyn, New York, and found over a series of time 7 or 8 entities that were created with this very similar format for existing businesses around the state. right now we don't have the tools to really address this. That's say in terms of the authority or powers available to the Secretary of State. Other than the Securities Regulation Group, we're not an enforcement office. With respect to corporations, the Business Corporation Act says that basically, if it's complete and if they submit the correct filing fee and we can index it, that we're required to take it, and it has no determination whether or not that filing is legal or illegal, or whether it's authorized or unauthorized. What we'd like to do is have the ability to remove those types of filings from our records. As Hovey said, that people look to the business registry, to our website, to validate the businesses that are existing, and that the information that they hope they can rely on is being accurate. So we want to be able to basically have a way for us to be able to remove those synthetic entities when we become aware of them. But also, with the benefit of technology, we're getting ready this year to issue an RFP to replace our existing system, and we know that using technology, we can find ways to address the issue where people are unable to successfully, using the anonymity of the internet, be able to pretend to be somebody else and to file transactions with us and create entities that will be used for nefarious purposes. The language you have here is substantially taken from a Connecticut bill. Our colleague, I work closely with the colleagues from the corporation divisions from around New England, and this was the language that they successfully passed in the state of Connecticut, that became effective January 1st of this year. I'd be happy to take you through the bill if you'd like me to do that, or we can wait till we do that in subcommittee. But
Yeah, we'll do that in subcommittee.
Yeah. So basically, that's the intention of the bill. That's what we're trying to accomplish here, and be happy to answer any questions that you might have about the bill or about these individual situations that have occurred that we're trying to address.
Representative Salva has a question.
Thank you, Chair, for taking my question. My question is, when we form the company, we give all kind of information to the Secretary of State, and you guys verify the data and then give us a authorization to work for any businessman. We have a good standing certificate which you guys provide. So during that process, do you not validate these things?
That is correct. We do not. Folks do not have to present identification to us when they complete a form and to file it with us, whether they do it online or in person. So yeah, currently there is no validation. That's when the business corporations were previously, the statutes were created, obviously, prior to the 1970s, when you were to form a business, file anything with us, the signatures had to be notarized. And notarization came off of these forms back in the 80s when we started to computerize. We wanted to make it simpler and easier for folks to be able to complete electronic transactions. And so with that, the ability, the duty to verify who that individual was removed from the statute. So currently, we do not verify who they are.
Representative Burrows.
Thank you. Just a quick question. Thanks for taking my question. Do you know how prevalent this is? This is really identity fraud. Do you know how prevalent it is in New Hampshire?
The situations where it's been reported to us so far have been, I'd say probably, that I'm fully aware of, probably it's happened a couple dozen times here in the last 2 years.
So, as someone who has some corporations that are registered and a nonprofit too, I know that in the front end, I have to have a login to be able to get in to go and change that. So did some people somehow were able to get that person's initial what their login information is, or if somebody can crash the system and get in there and then start changing the membership?
The logins are tied specifically to an individual user account. They're not tied to the
Right.
business entities that they may be filing against.
That's
So
correct.
anyone could create a Quick Start account and then file documents against any other entity types.
Right.
One of the things that we're envisioning in our next system is that if a user, just like yourself personally, if you want to lock down your credit file, it means that you can do that with the credit bureaus. When someone forms an LLC with us, if they wanted to lock down their record, provide them with a unique PIN that they have to present each time they file a document, that we provide a way that we could
Well,
allow
it's
people
the
to do that.
annual, I'm thinking in terms of
Yeah.
I have to do it annually,
Correct.
Come January 1st, I get my, notifications. Used to be the little card, but now we get the email notifications, and I duly log in. But I never realized that anybody else could log in and then get access to the corporate entity that I'm supposed to be representing. In other words, is it? It is not tied. When I create that account, it doesn't say I'm the only person who can then change the board membership.
It does not.
Ooh, that's a. You got to fix that. That's a little scary.
Well, like they indicating the fact that say that the fraud has not been a dramatic problem. As I said, the vast majority of our businesses are legitimate. They attempt to file properly. Most folks, in fact, when they file their annual report, if there's been no changes, they're not required to log in. Only if they want to make changes do they have to actually log in.
Well,
and do that.
past year, but every year I got to log in to pay my fee.
As I said, if you have any information that you need to change, otherwise, if you have no changes to make, you can simply
Do
provide
that.
your
I can
credit
do that.
card.
But what I'm
file.
saying is that you have my identification because I'm that personal log in. Wouldn't you make sense that I be limited to access to be able to change any of the corporations to the ones that I am officially registered to?
That's one scenario that we're envisioning we could provide with our next system.
And
if
it would
we
make
had
my
that
life
for it.
easier too, because if I just log in and then pulls up my list, then I can bada bing, bada boom, and take care of all of them that I have, rather than I unfortunately have several logins.
Well, I mean, to your point, being that that is certainly that's one approach. The thing is, oftentimes we find too is that an attorney or a service company like LegalZoom will create your business for you. Then after the first year, you may or may not still have them as your registered agent. You may want them to do your compliance for you. You may not. If you're doing a transaction with your attorney and the paralegal needs to go in and file an amendment, that sort of stuff. There are any number of users who would have a valid reason to go in and file documents against that entity. So the login doesn't prevent others from doing so. But like I said, we could create a model
Okay.
where you could control access to that.
Well, at least nothing else is that I get notification that somebody else logged into that account. Logged in and made a change, and they say, "Were you the one who did this?" I mean, Google does it to me all the time. Every time I redo a computer or something like that, it sends me a notice and say, "By the way, we just noticed that you had a new person logged into your account."
Yes, sir. Our system does do that. That for if someone files that annual report filing on your entity, if you provided us with we call a business notification email, that email is notified that a filing has been filed against that business.
Okay, feel a little better. Okay, we'll take it up in subcommittee. Oh, we do have a question. Yes, Representative Purcell.
So, I'm looking at enables the Secretary of State to verify and prevent fraudulent business formations. Are you now saying that you want to require the Secretary of State to take these verification?
They are the
act-
Secretary of State. That's who they are.
Right, but are you, is this a requirement now going forward?
I would just say this is enabling and not for every single transaction that comes through our department. We're not going to.
They don't have the same relationship with the Attorney General's office that most of our departments have. So they do everything by statute. So the statute needs to clearly say they have the right to take misinformation down. Okay. Whereas most departments would contact the AG's office, and the AG office could.
So
take it up.
that's why the bill states on page 2 and line 15 and 23, they may verify data or may take the following measures and are not required to do that?
Correct.
May versus shall.
Correct.
Okay.
Yes. And I will say there is a process currently in law, but it's a very lengthy process where letters have to be mailed to the address. We have to wait for a return letter to come to us from the post office, and 60 days. Tom can go into
Right,
more in the subcommittee hearing. But
I got Pony Express delivering mail to me in Ringe, so. Okay, great. Thank you very much. All right, we will close the public hearing. Natch, I'm sorry. Okay, reopen the public hearing. Natch Grace from the BIA has some concerns.
Yes, Mr. Chair, Nate Graves with BIA again. I can put my comments in a letter and email that, or an email and send that out to the committee this afternoon, if that would be
That would be good.
easier.
And you'll show up to the subcommittee.
Yes. And
Okay.
that's, I think, at this point, what we're asking for, because we have a number of questions with the language of this bill. We certainly don't object to the point. Let's take care of the bad actors. But at the same time, just based on how it's drafted, we have a number of questions.
You got 2 weeks to work with Tom and get it figured out.
I got it. I'll give my people the deadline.
All right. Thank you.
Thank you.
Okay. Now I'll close the public hearing. 406. And so what are we? We're half an hour behind schedule. Okay. So let's try to be back here by 1:30. You. Okay. All right. Open up the public hearing on 275. And
Representative Flanagan is here.
is here. And you're the prime, right? Yeah. Oh, the only. All right, let's do it. I have a card here, right?
Yeah, 275 should be in there.
There we go. Jack Flanagan. Mason. When did you move to Mason? No, you should look professional. You have to. You gotta. Things have changed since you left. We're very high tech now. And all I can say is and caution you is to be aware that everything you say or do is going to be preserved forever on YouTube. All right.
Thank you, Mr. Chair. and
What you
thank-
said.
Thank the committee members for taking my bill under advisement. For the record, I think I represent the largest flotorial in the state of New Hampshire. It consists of the towns of Hollis, Brookline, Mason, and Greenville.
No, there's more.
It's almost the same size of our senator, except your senator includes Ringe and part of Nashua. So it's a big district.
Yes.
I'm presenting House Bill 275, and Mr. Chairman, you might remember a conversation.
Act like the mic is
my friend
in your mouth. Yes.
No. So you'll remember a number of years ago, we spoke about insurance companies requiring healthcare providers to have additional training. And this is training over and above what their colleges and their, what would be internships.
Oh, it was board certified was the magic word.
They are through the OPLC.
They'd be board certified.
Right. And the OPLC also gives them their licenses. So what happened was I had a dentist that I had through an Anthem policy, Medicare Advantage. And that insurance company told my dentist that he can't be certified with them until he has his entire staff to have LGBTQ plus training. So in other words, the teeth of that group is different than all of ours, I guess. I have no idea. But he refused because he had 4 locations. So the cost would have been very prohibitive. And I know, Mr. Chairman, how much you hate putting costs back to the insurance companies because the insurance companies always hit the insured with it. Makes sense.
That's by law under Obamacare.
Okay. However, when they want something and it's not required for the certification or the licensing or the approval of the healthcare provider, I thought it would be reasonable that they pay for it and spread the cost of that requirement over the entire country instead of maybe the people in the state of New Hampshire, because if they didn't get reimbursed and did do the program, that cost would be borne by the patient. Or if they didn't do it, they would have to go to a different dentist, doctor, or whatever healthcare provider. So it really put the consumer in a conundrum. You can not go to and go to a different doctor or dentist who have got a lot of faith in, or you can get a different insurance company, I guess, or you can pay for the insurance with the dentist doctor that you have faith in. So I thought that was wrong, because ultimately it's the insurance company that's making these requests or demands on the healthcare provider, and I feel that they should pay for it. Now, a couple things is when I first broached this with you, Mr. Chairman, I couldn't find where in law I could put this. But thank goodness for the OLS, they found this managed care provision, which is what most HMOs are, and it fit right in there perfectly. So I also want to talk about the fiscal note here, which when I read it, I was like going, did they really write this? Because they talk about, first of all, they avoid the OPLC as the licensing of healthcare providers. And it's almost like they're putting the demand on the insurance companies. And it's actually the other way around, is the insurance companies put the demands on the healthcare provider, and they have no licensing provision. They have the certification provision as far as being the approved healthcare provider, but they have nothing to do with the state approval as it relates to their licensing. So I was thinking, well, they didn't do a lot of research on that one, because I talked to a number of physicians. Even remember Joe Hannon? Yeah, he was just downstairs at a marijuana.
Not a surprise.
Yeah. And I asked him, and he confirmed that the licensing is all done by the certifying body in the state, and really the insurance company is just. And again, I'm using a little stretch here, but I think if they can approve the price of the service, you'll get approved unless you have some type of bad history, like malpractice and things like that. So with that, I will gladly accept your hurdles thrown at me.
Representative Spears has a question.
The example that you used was Medicare Advantage.
Yes. Mm-hmm.
I don't think we have that much control over Medicare Advantage. I mean, we can't, it's not like we can legislate against those guys. Do you have any example of an insurance company within the state that's under the control of the state?
Well, my policy, and thank you for your question, my policy happened to be through the plan, and I didn't send, I don't think, a complaint to them. Maybe I did, I'm not sure. In typical fashion, I probably didn't hear anything from Anthem. But the reality is if they have to comply with the state law because they're licensed in the state of New Hampshire. So, and I know what you're saying. It's because I have a background in insurance too. But if the policy is paid for by Medicare, then I think it's a little different than the laws within the state in which they do business.
This 420J is, as far as I know, that is the small employer fully insured. It does not include Medicare supplemental. It's 420J is our managed care statute. So it only technically, as far as I know, but we'll have some people from.
Well, when you put
who
it,
might know better than I do. But,
when you put it into a subcommittee, which hopefully won't be next week because I won't be here, but I'll gladly attend.
It will have to be 2 weeks from now.
That'd be wonderful. I'll be more than happy to do whatever research is on that. Yeah. And you bring up a good point, Representative. I know I have contacted, was it CPM, CMS? Yes, on other issues. I'm not sure if it dealt with Anthem or not, but I'm glad that it's being recorded forever and ever.
Forever. Representative Ammon.
Mr. Chair, thank you, Representative, for your testimony. I'm trying to wrap my head around the concept of this bill. It sounds like this could be considered an unfunded mandate from the insurance companies onto the providers. Is that a correct, loose understanding of it? High level?
Yeah, thank you for the question. I didn't really think about that, but yeah, I guess if they want to, it's a pay for play, right? If you pay, then you continue doing business with, I would imagine, the largest insurer of the state. So yeah, it would be pay or play, or it would be unfunded. Yep.
Representative Burrows.
Thank you for taking my question.
Certainly.
I first of all, I want to make sure I understood you. You seem to be saying that credentialing these insurance companies is a quick thing. Is that what you implied?
No, I'm just saying is they're asking for training of these either physicians or in this case a dentist that isn't part of the certification to become a dentist or a doctor in the state of New Hampshire, and they want the professional to pay for it. And I'm just saying is if they want it, if the insurance companies want this type of training from the doctor that's not required for the licensing, then they should pay for it.
Thanks.
Wasn't there a question over here too?
So we do have other people going to come in, but in my, I guess my little experience here, what this section was about was a insurance company had maybe rejected someone to be in their network, and because the insurance company had certain requirements, and it says solely. Okay, it said solely because of their meet the health carrier's credential verification standards. What you were describing is a training course, not really a certification, but this would go back to where I was saying being board certified. And this is about getting in the network. Okay. So I want you to first know is that not every healthcare provider can get into a network. Okay.
Correct. Yep.
That the healthcare provider, the insurance company can decide how many people or whether they have enough people in their network and therefore met the network standards that they had enough people in the network.
Can I respond to that, Mr. Chairman?
Sure.
Most of the time, in talking to other, healthcare professionals, the basis is on money. In other words, we will do the business, we'll cover the insurers at X amount of dollars, and that covers, what the insurance companies want to pay. So, and in this case too, the example that I gave you was not really an issue on training. It was their social score, their social equity score on, their ESG score.
We have that as a separate bill.
Okay.
So in this case, the issue, because you were talking about money, and you're absolutely right. It is about money. We have in this committee, we have the ambulance issue.
Oh, God.
And the ambulance issue is that the ambulance providers refuse to sign a contract because they want to back bill. They want to get all their money. They don't want to take that lower amount that's agreed upon. So it is true that an insurance company says, okay, it's all about the money. You say, this is what we want you to do.
Yep.
And you have to decide whether you're willing to accept that or you decide that you don't want to be a provider for them.
Right.
Which I've always heard that was the reason why most dentists didn't do too much
Medical.
in network. But
Yep.
most dentists, it's all about Delta Dental.
Correct. Yeah.
Okay. But in this case, the fact that you dropped in this sentence into that statute, it's a little, it doesn't really flow normally. It's not really, they're like two different subjects. In terms of paying for those certifications, paying for there's no reason why an insurance company would pay for standards or certifications or justifications. The issue would be, normally you would say is that they didn't offer you a contract, they didn't do business with him because of his credentialing, but having this this course and having his employees take that course, it's not credentialing anyways.
Okay.
Okay.
Well,
So, but I do want to say is, because I always like to take this as an opportunity to educate people about premiums.
Me too.
About premiums. So premiums, thanks to Obamacare or Affordable Care Act, premiums are absolutely governed by what the insurance company pays out. So if they pay a provider anything, that goes into the basis, which they do a 3-year rolling average.
Correct.
And that will determine the premium.
And if there are less claims, then there's a refund given to the insurer.
No, that's old news.
Well,
There's no refunds anymore.
I got
Okay,
one. I was pleasantly
right now,
surprised.
we're talking about how they set the premiums. Now, what would be interested is is to say is, oh no, this should be an obligation of the remaining 10%, which is what the managed care company has for their profits and marketing and advertising and
Okay.
and paying for their employees and the salaries for their CEOs, but which it just I have no idea where this would go, but I just wanted to say is this is totally disjointed in where it's located in the statute.
I stand corrected because we rely upon our faithful OLS people
I
to do
think
it.
they looked and
They thought it would be a good place to put it.
Nice place to put it.
Let me also add to the comment that you had. Businesses don't like to tell other businesses how to run their business. In other words, let's use an example of, say, the insurance company said that they had to be trained on a certain type of medical care before they could be approved. Well, then they find out that the medical care that they're telling them to learn about and do causes more harm than good. The defense the doctor could have was, well, the insurance company told us to do it, and they wouldn't certify us until they did it. In other words, there's some liability that when someone tells somebody to do something, there's inherent liability.
I've never heard of that before, that an insurance company would tell somebody what to do.
Well, I just cited you one.
No, this is
Mr.
I
Chair?
this is some, I don't know.
Mr. Chair.
Yes.
Can I just, would you believe? Okay, let's say they tell somebody they have to have some certain kind of training. I don't see it as being a potential harm to a patient because they have to have hospital privileges to do certain things. They're not going to just be allowed to do whatever. They have to be privileged to do it. And that goes through the credentialing from the hospital side.
Correct. There's no doubt about it. But they will also suggest another drug, but they will suggest it if you're on a prescription, but they won't demand it because they don't know the entire patient history. So I'm just saying is, yeah, but the healthcare provider has to have some latitude, but the example that I gave where they told them that they needed this training, which had no bearing on the service they were providing, the doctor or the healthcare provider would have to have the burden of paying for 4 offices to get that training. Someone's got to pay for that.
But I was responding to, you're saying that it could be
Further
dangerous
question.
to the patient. And I don't see that at all.
Thank you. Oh, well, we have more questions. Representative Teresa.
So I think, thank you, Chairman, for letting me ask the question, and thanks for taking a question. So I guess based on the conversation that we had, most of the times the insurance company and the provider, when they don't agree on fee structure, that's the reason they reject. Now, based on what you have presented, have you seen a lot of instances where the insurance companies talks about some training or processes to be followed besides the licensing requirement by the state, and based on that, they are turning down the provider? I'm just trying to understand that what exactly prompted you to bring this?
Well, thank you for the question. Well, I've had firsthand experience in this one instance where they were asking for what I felt was ridiculous training because, like I said, the chairman's teeth and my teeth are all made by the same material, and we should probably have the same number, although probably have lost a few myself. But it really had no bearing on the services to be provided, and I wanted to make sure that it didn't happen to anybody else. And better yet is if they wanted to do something for the healthcare provider that wouldn't be in the normal scope of things, then it shouldn't be asked. Or if they want it, they should pay for it.
Further question, you may inquire.
A follow-up. So, I mean, that's one instance. My question was more like, have you seen many instances of this? And can you be more specific? What kind of trainings they ask and they reject based on that,
Sure.
the provider services?
Well, the only time you'll hear about it is when the doctor is denied, what would you call it?
Refused to do
refused
business.
certification or whatever, okay? So in my case, because of my background too, they shared it with me, and they shared me why, and I thought that was unacceptable. Now, my primary care physician is part of the St. Joseph system, and right now St. Joseph's battling with Anthem, and they're not willing to pay them, but I don't know the specific details of that, but I do know that they had 3 times they went to get adjustments to their pay scale and they've been denied, but other hospitals were only denied after twice. So, yeah, there's only so much you can get from these healthcare professionals because you don't want to they don't want to share the problems in the back room. But in this case, they did. And I thought it was totally unacceptable that my healthcare provider had to take a special training, which had no bearing on my teeth, okay, and have to pay for it themselves.
Okay, Representative Gibbs.
Thank you, Mr. Chair. The training that you referred to that your dentist was being told he had to provide for his employees, that wouldn't actually be a certification, but it would be a program under the language in your bill. Wouldn't that be correct?
That's what I'm trying to get. Yeah, but the chairman tells me it's not in the right place. So when the subcommittee meets, I'll try to find the right place and we'll make that change. But yes,
It would be a program.
it would, yeah, training program, sure, yeah. Right.
Thank you.
Yeah.
Thank you very much.
It's always great to see you, Mr. Chairman.
Always a pleasure seeing you, Jack. Okay, the chair will call on Michelle Heaton from the New Hampshire Insurance Department, who takes no position on the bill.
Good afternoon. For the record, my name is Michelle Heaton. I'm the Director of Life and Health at the New Hampshire Insurance Department. We take no position on this bill, but we'd just like to highlight some of the concerns. I think you guys have already touched on a lot of the issues, but the concern we see is with the broad language in which this is written. When you say any additional program or certification, that is very broad and I think could have a lot of unintended consequences. That could be all different kinds of program and certifications that are required across the healthcare system. So generally, our managed care laws do not set some very loose parameters about what needs to be in the credentialing process, like the provider needs to be licensed and there's certain consumer protections that need to go in the contract. But other than that, usually carriers, it is their prerogative who they want to contract with and have part of their network. So that's why in doing our fiscal note, given the broad language, we have, it's hard to quantify what type of ramifications this would have, but it would likely increase premiums because there would be additional costs that carriers would have to absorb, an additional administrative burden. So I'm happy to answer any questions.
Representative Spear.
In the small group and large group fully insured market, which is what we usually handle, not Medicare. In that group, have you ever seen a complaint of this kind? In the group that we actually can issue laws about?
No, I mean, we routinely get inquiries and complaints about credentialing generally, but never about having to take any specific type of course or training as a barrier to credentialing.
Just to follow on that.
Further question, may inquire.
Is there any place in our laws, and of course I don't know them all, but in your case, you probably do, where we would be able to control Medicare in this particular case?
No.
So we would have nothing to do with this anyway?
Yeah, if we're talking Medicare Advantage market and the products that were previously being referenced, we have no regulatory authority over that whatsoever. And I know there's mention of OPLC. OPLC sets licensing requirements. So I don't know that if it's not a licensing requirement, I don't know that that would be an appropriate place. And again, I'm not sure who is going to be responsible for paying for this. If it's a carrier requirement, it would make sense for it to be in insurance, I guess. But we would suggest having a much more clearly defined definition as to what types of programs or certifications we're talking about. And that, again, would inhibit the carrier's ability to contract with whoever they please, which is kind of a key portion of credentialing.
Thank you very much. Okay.
Is she opposed?
No, she was just giving information.
Okay.
Yeah, info. Okay, so Sabrina, you're the one offering up the opposition. But I do want to know from Paula how long this law has been on the books, this original law. Because we've both been around long enough, this must have happened under our watch. I just don't remember it.
Thank you, Chairman Hunt. My name is Sabrina Dunlap. I'm Director of Government Relations for Anthem. I'll be brief. I will say when we first saw this bill, we were sort of befuddled and confused about what it was trying to get at. I repeat the concerns the insurance department already flagged. I do just want to note, since I think Anthem's name was invoked in sort of a disparaging way, that Representative Flanagan did reach out to me in December of 2022 about this issue. It involved a third-party administrator who I think Anthem must use in the Medicare Advantage space, which is way outside of my realm because it is a federal program. Nonetheless, I wanted to be helpful. And so I reached out to this third-party administrator who's not Anthem, and I inquired about a compliance program that they had. They told me it was required by federal law, and they said we're obligated to downstream the requirements for cultural and linguistic competency training to our staff, and by extension, our contracted providers under a certain federal code. The material includes communication tips and best practices for servicing a diverse membership based on race, ethnicity, religion, sex, gender, etc. So this was something this third-party non-Anthem entity was doing as they were required to by CMS. I provided that information to Representative Flanagan on December 23rd, 2022. So I just wanted to clarify that we had that conversation. So I'm happy to take any questions, and thank you for the opportunity to speak.
Okay. You really want
Really quick.
Okay.
How do you keep notes about stuff like that? And how are you able to find it?
Thank you for the question, because it can be helpful to pull up receipts when I need them. So thank you.
Okay. We'll close the public hearing. This bill will go to subcommittee and will be dealt with. You pay attention to the calendar, and A or B, you will get a notice from the staff when we do it. So figure another 2 weeks. Yes, thank you. Okay. Moving right ahead, let's take up House Bill 241. And this one we have a lot more people interested in participating in. We'll start out with the prime sponsor, Representative Nagel. Yes. You're on. I assume they told you that when you're right. No. Oh, that's nice. Right. We are.
All right. I'm honored to present House Bill 241 from 2025. Here we go again. Thank you for the opportunity to do this. This bill has been the work over at least 10 years of multiple people from all over the state, the country, representing multiple stakeholders, working together. Even though some of us behind me may oppose me, we've always worked together, and hopefully we can come to a solution on what's a difficult problem. My name is Dave Nagel. I represent the town of Gilmanton, Guilford, and a little bit of Laconia. That's not why I'm here. I'm here because I'm a doctor. I've worked with people with complex disability my entire career. Pain is one of those disabilities. I've been involved in pain care policy in this state for over 30 years. And I also advocated for people with pain for pretty much that entire time.
This is my book, some of which we'll be talking about. I was honored this book was a catharsis because I was angry about how we deal with the issue of pain in this country. It was never meant to be anything more than that. I was told that this was a Bible for people in pain. So we published it, and this book is now sold all over the world. There are chapters on here that on issues that we will be discussing today. I also want to say that I represent the 66 million Americans who suffer from chronic pain, the 1.5 million in hospice and palliative care every year, the 50 million who will have a surgery every year, and the unknown tens of millions who will have a moderate to severe pain from an acute injury. One of the groups that I do not represent directly, but I'm very proud of, are the veterans of our country. The incidence of chronic pain in combat veterans is 60%. You need to know that the VA actually provides all the services we're going to be talking today in a comprehensive, integrative way. The Department of Defense does the same thing. If you get injured on the battlefield, you will get battlefield acupuncture, which is something that you need to know about. So in sum, if you were in the, we also found out in our work with my other integrative pain care committee that hospice provides all these services, but palliative care patients cannot get them. So if you are near death, or you were in combat, or you're a veteran, you can get access to these services that we'll be talking about today. But if you're anybody else, you have limitations. I also, did you talk about the fiscal note, the note that was in,
We haven't talked about anything about
right,
this bill.
just the fiscal note that I saw as inaccurate. It actually refers to last year's bill or 2 years ago's bill. So we can talk about that later. One of my other roles is I got asked to develop a pain care policy for the NFL. And that was a fun thing. Nobody had ever done that before for elite athletes, and I was excited to do it. This is what we came up with. But as in the process of doing that, I interviewed hundreds of professional athletes. And the one thing that's true about every professional athlete is at some point they retire. When they retire, they have to live with what they've done to their body through the time that they were an athlete. So one of the players that I worked with, who was kind of symbolic, he was a gentleman that played in the NFL for 17 years, was lucky enough in his 17th year to win a Super Bowl, had 17 surgeries, one per year, and had chronic pain. But while he was a player, he was able to access a variety of therapies that we're talking about, specifically chiropractic, acupuncture, massage, mindfulness, things like that are pretty standard basic therapies for pain. And he was able to utilize all these therapies, and restorative, I mean, they all exercise, which is really important. He was able to utilize all these things and control his pain despite 17 years of being, an athlete in a pretty rigorous sport. What he told me was that what he told me was that the minute that he retired and went to the private sector, he didn't have access to any of that stuff. And as soon as that happened, at least not in a meaningful way, and the minute that happened, all of a sudden he's got to piecemeal everything together. He was not like an elite player. He was not a bubble player. He was somewhere in between. He made a good amount of money, but not, a lot. And so all of a sudden he has to figure out how he's going to pay for this or not. And what he told me and what we found out from interviewing athlete after athlete after athlete is that they frequently turn to the bar room to deal with their pain. Alcoholism is very common in retired athletes, and that's what he did. The new rage is cannabis, and I know cannabis is the next best thing for everybody, which is totally another story. But anyways, a lot of athletes now are using cannabis for that purpose, which is not necessarily a good thing when we think we have much better ways to deal with this problem. This problem doesn't just exist in professional sports, it also exists in the community, and that's what we're talking about today. To address this lack of access, there's a couple studies that have been done under great taxpayer expense that have all come to the same recommendation. This is, you have to read this by tomorrow, but this is the National Pain Strategy from, 2014 or something? 16? Yeah. Cindy's a genius back there. She'll talk to you later. The first CDC report on opioid prescribing from 2016. This is a report from the International Olympic Committee looking at the same issue. Ms. Steinberg will be talking to you later, as one of the authors of the Health and Human Services Best Practices on Pain Management report released in 2019, and then the CDC report on opioid prescribing in 2022. What all these things have in common is one thing. They say, number one, we do a rotten job of managing pain in this country. Number two, what we do, it's not cost effective at all. And number three, we must provide access to a number of these therapies, alternative therapies or whatever. And that is the conclusion from all these studies at the federal level. So it's important. If the VA can do it and the DOD can do it, the question then becomes, how can we do it? And the NFL can do it too, although they make more money than we do. The purpose of this bill was basically to resolve this issue. When you look through the bill, there's three parts to the bill. The first part is a preamble, and I would ask that you read that. It basically gives why this bill is important. We are harming people with our failure to treat people in pain. We have a suicide watch that we maintain. It's become significantly worse since the opioid crisis because now patients can't get access to opioids, so they have to go to other things. And everybody's saying, you need this, you need that, you need this. Chiropractic, acupuncture, massage, whatever, but then we don't provide it in any meaningful way. So all of a sudden they're left in limbo and they go to the streets to get their pain managed. And that's not very often a good thing. The second part of the bill lists a series of interventions, and this is the most fun part of this bill for me because we worked with the insurers to come up with this list. One of the conclusions that we made is that any service to be provided needed to be provided by a licensed provider using reasonable evidence base. So there is decent evidence base on acupuncture. The medical acupuncture practice evidence project lists 117 medical indications for acupuncture that have evidence. The second part is chiropractic. Amy Goldstein from the Alliance to Advance Comprehensive Integrative Pain Management delivered a report to our Integrative Pain Care Committee in which she outlined the chiropractic is actually the most cost-effective way of dealing with acute back pain. Guess who's the least effective, cost-effective? Spine surgeon. Guess to where most patients go? Spine surgeon. Makes absolutely no sense, but that is what happens in practice. And then the third thing is that it's in section 5 of each of there's two different parts, group and accidental insurance. They're basically the same thing, but Roman numeral 5 I think is really poorly worded. I'd be happy to work with you on it. I've never been very comfortable, but the point of that is this. I'm very concerned about the way we use evidence base in defining what we're going to pay for. So for example, the bar is very different for an alternative therapy than it is for a quote allopathic therapy. For example, there is virtually no evidence to support the use of pedicle screw fixation in spine surgery for anything. The morbidity after that procedure is tragic. The outcomes are not tremendously good. It doesn't mean that nobody does well, but the surgery is done way too often without really sufficient indications, and the outcome data stinks. But we pay for that. At the same point, we have really good evidence to support chiropractic for acute back pain. Cognitive behavioral therapy is a psychological therapy, which really should be doing in almost everybody with evolving chronic pain to chronic pain. And we have good evidence for those, but we don't pay for them. And I want to give you one example. I am an acupuncturist. I basically retired from that the minute I helped create the Medical Acupuncture Practice Act, and we allowed non-physicians to do it. I have one patient I've treated for 30 years on a monthly basis. Her cumulative bill over 30 years is less than the cost of one spine surgery. And that's making the assumption your medical care stops after that spine surgery. It continues. So I wanted to create language that would mandate, I'm sorry about using the word mandate, a level playing field in how we apply evidence base. I know that's a dirty word, but I said it. Anyways, I think that's almost everything. I just want to conclude with one thing. Anybody here was a parent? Anybody ever spanked their kid? I always had oh yeah, you're not going to admit it publicly, I know. So I had a 3-strike rule with my kids. You're admonished once. If you don't do it, you're admonished a little louder. The third time is a quick smack on the butt, right? we've been here a lot to talk about this issue. And not to say anything negative about my insurance friends, but it's time that we really need to start acting on creating cost-effective integrative care. And we're not doing it. And this is an opportunity. It's a template to do it that I want to work with you on. And so if this is a third strike and a pat in the butt, that's fine with me. And one last thing. Always one last thing. Last year, I brought you a bill on prior authorization reform that we all worked on together, right? We had a wonderful time. And it was a great experience. And the best part about it is when we sat down, our bill, when taken in with federal legislation, the Congressional Budget Office, which I know is never wrong, said that we would save $15 billion per year in terms of healthcare cost by doing that. I'm pretty sure, and my friend back there will give you more data on this, that we will save money doing this, and we will also have less morbidity, maybe less mortality at the same time. Any questions?
Okay, Representative Sullivan.
Thank you for coming in and taking my question. I'm just curious. I mean, I don't think it would be in here, but you cite a lot of things and how this would be all cost effective. But is there good estimates, like, because it might, and be clear, like, even if costs go up doesn't mean we shouldn't cover something, but it certainly is possible that costs overall could go up if suddenly people are getting a massive amount of something that they couldn't get before. Doesn't mean they shouldn't get it, and maybe we should expand that, but I'm just kind of curious, if we're spending $1 million a year on treating chronic pain and we open up these things, does that $1 million go to 900,000, or is it now double the patients are getting care? I think you get my point. Or my question.
No, it's an awesome question. I think there's a number of different ways to answer that. The last number that was given of the cost of chronic pain per year was from about probably 15 years ago, was $650 billion a year chronic pain costs this country. So it's not a trivial number. And it's really important that we become substantially more efficient with that. When we designed this bill, the reason why we limited it to 12 was because of that. Like, if you go to the VA and you get treated, they don't limit it to 12. You get what you need. And, it's obviously a different setting than the medical world is, but that is why we limited it to 12. The third thing is there's a challenge that I've delivered to my friends back there on several times. I go, we have an epidemic of pills and procedures that are very expensive. I'm an interventional spine specialist. God only knows what that means, but it means I use long needles to put into people's spines to deliver cortisone. I've never sat down and figured out how many different procedures we do, but they're all very expensive. And what they all share in common is there's no evidence to support any of them. And so, but we pay for that. And then surgeries, I already gave you an example of a surgery that we know doesn't work. In fact, the only surgical intervention for pain that we have any clear evidence that it works without some of the oncology things that we do is disc decompression for herniated disc. That has good medium to short-term outcome data. But after 2 to 4 years, you're kind of back where you were. It's not a cure, in other words. So my belief is, and this is the way we do everything in medicine, or we should be doing, is we start superficial and inexpensive, and if that's not working, we migrate up to these other things. But the problem is, if you don't pay for these things first, you accelerate the migration to the expensive stuff. So to some extent, the cost savings are theoretical, but I will tell you, I'm sorry I didn't bring somebody from the VA to talk about it, because a couple of years ago we did, and they did find that this is a lot cheaper for them to do it this way. And patient satisfaction is dramatically better.
Representative Burrows.
Thank you for taking my question. Do you have data on the efficacy of all of the methodologies that you have in the bill?
I can get, there's a wealth of it. To be honest, it's in all the,
Okay.
in the footnotes of all of these things here, but we can get that to you. Cindy's back there. Amy, they're my two best friends. Amy Goldstein, if you want, she gave us a wonderful presentation. Amy runs the Alliance to Advance Comprehensive Integrative Pain Management, which is a 92 there's 92 types of stakeholder groups that look at this to try to deal with the issue that we're dealing with now. And she gave us a presentation that has a lot of that data. That's where we got the data about the chiropractic, the acupuncture evidence project. I can give you the link for that. Massage is a little bit more tenuous in terms of getting the data for that. We're going to have some psych folks talking to you later that can probably give you that data better than I can, but it's also in here.
Thank you.
So if you want, I can give you all these
I don't need,
references.
I don't need.
You sure?
No, I just wanted to know that you've looked at all of these.
Oh, yeah.
Yeah, okay.
There's only 2 people in the world that have read these entire things, and they're both in this room, so.
I won't be one of them, but thank you.
Okay.
Representative Hammond.
Thank you, Mr. Chair, and thank you, Representative Nagel, for your testimony. I'm just trying to understand the bill. Maybe there's a simple explanation for this. I'm trying to find the limiting factor on the mandate. So we're trying to mandate these modalities. What's the limiting factor? And when I see page 2, line 1, that section there, I see including but not limited to, in all 3 of those sections. And then and the first one says and or other meditation training, support groups, and pain education. So what's the limiting factor on what is being mandated?
Good question. I think I knew you were going to ask that question, and I actually looked at that this morning, and I think that we need to work on that, because there needs to be some limits to that. First of all, our goal when we wrote these things up was that it had to be provided by a licensed provider. Some of these things here are not. So, like, for example, if it's something that a psychologist uses as part of their training, then that's what we would want to include in that. For example, they use mindfulness, they use cognitive behavioral therapy. These are all tools they use, meditation they use. But I think we need to specify in that section that it be provided by a licensed provider. In this case, it would be a psychologist. Does that help?
Yes, thank you.
Yeah. Thank you for pointing that out, because I was looking at this morning and I totally agree with you. That needs to be firmed up.
Representative Sullivan.
Thank you, Chair, for taking my question. My question is, like, we are giving the 12 visits we are basically thinking about in the bill. How the patient might get used to it and then they need it more. How we are going to control that, because it is becoming a factor with the medical professional as well as the patient.
Yeah.
How they push it and how the doctors uses it, because there will be a lot of la la land where it can go in a different directions.
I will not argue that that's a challenge. My goal in pain management is to give a patient the skills they need to manage their pain on their own, which we really don't do a very good job on. So that would imply that there's a finite amount of therapy. The problem is that what does that mean? We use a patient-centered approach. Like, I had one guy come in, and after one visit, he knew how to manage his pain, and he's going to have pain forever. And with one visit, we were done. I was like, wow. For other patients, it's 13 years, and it's an adaptation process that people vary in. So whatever we do needs to be adaptive, but I do get there needs to be limits at some point. I should give this example, but I had a patient with spinal cord injury that's got chronic pain, and obviously being quadriplegic is kind of a tough thing to adapt to. Took her 13 years to realize this was the way the rest of her life was going to be. And then it becomes difficult. Do I not treat your pain in a self-managed approach for 12 years because I've put an arbitrary limit on one? That's where it gets hard. My world is I always work with patients and I stay with them. I don't like to abandon patients, and unfortunately taking this job I functionally did, but I like this job too. But it's a challenge, and I think, we've talked about a work group to sit down, and that's an issue that we have to come to some conclusion about, but I just don't like abandoning people just because they don't follow a timeline. So does that help?
Okay. Oh, Representative Sullivan again.
Yeah. Thanks for my second question. So you just said to him, you said earlier that we don't do a good job in teaching patients how to manage their pain and managing pain in general. I'm just curious, what is the definition of a good job? Like, is there a country that does it, a culture that's done it? Is there something we've done historical that we've forgotten? Like, is there, like, how do you define it? It seems a bit nebulous.
I'm glad you asked that. That's a really great question. So, the nicest, I don't do acupuncture anymore for the most part, but the best part about it is I got to look at Eastern culture's ways of doing things. And in American culture, we tend to be very myopic. So we will look at pill here, surgery there, therapy here. It's not integrated. And that's just the way we do things. And I'm not totally sure why, but it's very linear. We're in Asian cultures, things are a little bit more circular. So we look at Asian medicine as acupuncture. Well, that's not true. What Eastern medicine is a combination of a restorative thing, like a martial art, for example, a mindfulness thing like meditation, or like Tai Chi, Qigong, or they're movement things, but they're also meditation or mindfulness things, herbal things as a medication, and then needles as as acupuncture. So they use all four things together. And what we find is that when you use Eastern models in an integrative way like that, is that people adapt a lot more quickly and come to a self-realization that this is where things are at a lot quicker. One of the bigger problems that we have in this country, I think, is that it's all PR. Like in healthcare, watch every drug commercial on TV. You take this drug and you're cured. I listened to 7 hours of testimony on cannabis yesterday and had to scratch my head. Oh yeah, cannabis is a cure for everything. I mean, that's the way we look at things, and it's just not the right way to look at things. We promise something we can't deliver. So the minute we stop doing that and we say, this is where you are, well, let's work on from here. And then people will go through an adaptation process that's variable from patient to patient in terms of how time that takes. I mean, some patients I'm with for like a couple weeks and they're fine. I already said that, but and then other patients, it takes a lot longer. There are patients here that can share their stories with you a lot better than I can.
Representative Post.
Thank you, Mr. Chair. Would you believe about in 2018, I had been through a car accident in 2013, and I went to 4 different surgeons, and they all wanted to do an operation, and I was always nervous about it and held it back. And the last surgeon I saw, they told me if I had a slip and fall or another car accident, I would be permanently a paraplegic. And I was going down to the bank to pick up a check, and I heard a gentleman speaking on NPR talking about pain. I bought that book.
Oh my God.
I went to that doctor, and I think I had 1 or 2 years of just a few injections, and I have never had a problem since. So I thank you very much. You changed my life.
Wow. You didn't know I staged this, did you? Wow. Thank you for sharing that with me. Would you believe that I have 2 degenerative knees, a biceps tendon rupture, a herniated disc in my neck, and carpal tunnel in both hands, and I put 4,500 miles on my bike last year, and I've never had surgery for any of it because I use I don't even take pills for my stuff. So, I mean, I try to practice what I preach, and I think and I don't cost the system anything by doing that. Except my wife, because she's nervous because I don't wear a helmet on my bike. But anyways.
Representative Gibbs. Yeah.
Thank you, Mr. Chair. Please excuse my lack of medical knowledge, but I'm not sure what you mean by teaching people to manage their pain. Does that mean that you're teaching them essentially to accept that they'll be in pain for the rest of their lives and how to deal with it? Or is it finding a way to actually stop the pain?
That is an awesome question. So when we wrote the NFL guide, that's the entire first section, is to teach people about how to manage their pain. No, I mean, it's a patient, everything's patient centered. There's some patients I have that eliminating their pain is reasonable goal. And you know, when you meet people on day one, you don't necessarily know who they're going to be, assuming you've seen them on day one. But in other patients, you know, this is going to be an issue. What, I can't get rid of your pain, but let's make goals as to what's a reasonable outcome. And you always focus on function. What do you want to do that you can't do, and how do we help you get to do that? So again, it's everything's got to be patient centered. And to be honest, that is the flaw with the system, is we kind of force everybody into a funnel rather than allowing us to take everybody as an individual and treat them as an individual. So the answer to your question is very individual. Does that help? And you can, this is available online, actually. It's called the Gilbertson Guide. If you Google that, it'll come up.
Okay. So here's how I see this.
Okay, Dad.
And I would say that probably truthfully because I've been doing insurance a long time. And in terms of my experience, you know, this is it's an issue that really is long term. You know, the pain is not necessarily going to go away right away. But I think what's interesting about this legislation is it is a classic the cart before the horse, or should I say, is a more like the chicken or the egg. I think the problem is that our medical care system, when someone has back pain, they go to their primary care physician, and the primary care physician refers them to the physical, you know, the doctor who, and that doctor say, okay, well, let's you know, have you in the physical therapy, let's try to do this and stuff. That doctor will never mention the word chiropractic. Never. Okay, they have a thing about
I will
chiropractic.
disagree with you, but keep going.
Well, maybe you were different, but I'm just telling you that most doctors think chiropractors are practice is sketchy. Okay, I personally believe this. All right, and what they want to do, yeah, they're going to send you off to the surgeon, right? Because you got this back problem, and surgery is the right way to go, right? But as we know, surgery is the most expensive way to go.
Yep.
Okay, so what we're going to say when we take this project on here is that we can't tell doctors what to do with it, because that's the whole point of healthcare system, is that they do know better and that we're supplying. But I'm going to refer to a certain section in your bill here on page 2, Roman numeral 5, and I assume it's the same again on this 2 sections. So point out for everybody for education, this is 2 different statutes. So you see on page 1, it starts with 415(6)BB, and then
line
you see the
31,
same
right?
thing all over again on page 3, where it says 415(18)H8. So these are the 2 different health insurance statutes we have in the state. Okay, one is for the individual, the other one is for the small group. I would say this is where I saw the word yoga.
Yeah.
It was still there.
We
didn't-
need to take that
You didn't
out.
delete. You deleted it from the first section, but you didn't delete it from the second.
You're right. We need to get rid of it.
That covers up our conversation we had this morning.
Yeah.
Okay.
That was a fun
Okay.
conversation.
But
I
here's where I
appreciate it.
want to focus in on. Okay. And this note says no insurer shall establish utilization controls, including prior ops or step therapy. This is really important to me. And that is, if someone has a back pain problem, we can't tell the doctor to say, don't send them to the surgeon. Don't send that patient to the surgeon. Only the insurance companies might say, when it comes to the prior auth, have they been to a chiropractic yet? Now, this is a revolutionary idea, right? Because we've never thought of it that is saying we're now saying is because we all think HMOs are evil, right? Curse of the world, okay? Because they manage us, okay? But the reality is the whole phrase, but I'm not sure if this is the step therapy I'm thinking
I
of.
think they're different, but keep
But
going.
I think
Yeah.
this is drug step therapy.
Yeah.
But I'm thinking is that what we want to do is think in terms of what steps should be taken first before you go to that surgeon. Why? Because the surgeon is the most expensive thing you can do. And that's the one thing managed care companies are great at, is to try to get us to do the cheap one first. Right? That's done under the prior auth. So I'm going to ask you to think about this.
Yeah.
Is add or rethink about how we're doing this. And that is that I know your bill is set up is that the insurance company is supposed to set up what they're offering. Okay? But at the end of the day, when we say what they're offering, we need to say to them is they can start off with those things that are the least invasive and maybe less expensive, and then move up to those higher, more expensive things. Okay, so I just want to let you know that I really have a problem with those limitations because I'm thinking that's where the answer is.
So I agree with everything you have said, totally. The only thing I don't necessarily agree with, I think doctors and chiropractors get along a lot better than they used to, but certainly when I started out, everything you just said was true. I'm numbering my friends, but I don't know if you
We do have you.
but he's my fifth best friend. He's back there. So,
what? I'm not going to be your best friend.
You're
now?
number 6. I'm sorry. I'm sorry. The list is taken, but actually, Representative Post went ahead of you. But
Right, that's right.
So,
because he's a happy client.
I mean, you basically gave me a segue to recommend my book. I mean, that's basically what I talked about in the book, is that fiscally doctors are totally irresponsible. And prior authorization does have a lot of value because of that irresponsibility. And, you know, with my prior auth bill, when I testified last year, I said very specifically that a lot of doctors won't like what I'm about to say, but I think they're a necessary evil because of the way we do things. You know, with that said, you gave me I hope you're not exciting me for no good reason, but like the concept of us working together, that paragraph stinks. It really needs a lot
I
of
just
work.
want you to say that's where I'm. If
I don't
we're
like
gonna
the
run,
paragraph,
if we're
yeah.
going to run on the concept is that we know that the number one problem is everybody's going to that expensive surgeon
Yeah.
right off the top, and
Mhm.
then with bad results. Then they finally come back and
Yeah.
look at these cheaper ones that they could have worked out right and not as intrusive.
I
and
totally
might have been
agree.
So the problem is we now have a conflict between what our healthcare system is designed to work in terms of getting our physicians, and now we're giving a whole new responsibility to insurance companies. So I'm not even sure they're too excited about this idea. Okay, so I would say is we have to kind of work. This is going to take an art form to get this to a place where everyone feels comfortable with what we're trying to set up here, with the goal that it's going to be the least, the least expensive way to get that pain cured. So knowing full well that the surgeon, and some people will say they'll say, God, I'm so upset. They forced me to do all these other things instead of going to the surgeon, and I knew that I just want to go to that surgeon right out of the block. Okay, that will be our number one problem. Okay, so having said that, I know that we have a lot of people who are going to want to speak.
Yes, you're right.
Okay, and so what I want to urge everyone to say is that we get it, we understand what we're doing here, right? We get and how we want to get to. So let's try to be aware that that's where we're going to go, and let's not belabor too much, because I think we all really get that each one of these different practices does something very helpful and is less expensive than what is occurring now in this country, which is the surgeon.
You know, if you had said that before when we started, I wouldn't have said a word. You would have. You said everything I wanted to say. Thank you.
Perfect.
Good job.
Thank you very much.
Thank you.
Okay, so we'll start out with Roberta Blades, pain patients, and friend number. What number were you? All right.
I've just had the flu for 2 weeks, but I've had antibiotics. I just don't want to get anyone else sick.
I've had my flu shots and my COVID shots, so I'm
Okay.
well, not worried.
Good afternoon. For the record, my name is Roberta Blades, and I live in Concord, New Hampshire. I have been living with chronic pain at least since 2016, when I had a major move that was wrong, and I was in screeching pain, went by ambulance to the hospital, stayed there 4 days, was treated with opioids, was discharged with fewer opioids than I needed to manage, went home, could not walk, and I had VNA services for at least 6 months to teach me how to walk again. I had to use opioids to move, so I took them in the morning when the VNA came so I could move and build up my endurance and strength again. But I'm not on any strong opioids now. I do take a variety of medications for chronic pain. The biggest change in my life was in 2017 when one of my medical doctors, who was giving me epidurals in my spine to help with the pain, he's in the room, you might know him, Dr. Nagel, he said to me, I said, there's got to be something more than invasive injections, surgeries, which I never had for this. I've had for other things. There has to be more. And he said to me, look up uspainfoundation.org. And then he introduced me to Cindy Steinberg, who's in the room, who you'll meet, who is one of their advocacy people. And she became a mentor of sorts. I went to her support group in Arlington, Mass. And I made the trek because she was amazing and taught me so much. And now, shortly after, I went through the training, and now I lead support groups for the U.S. Pain Foundation as well. And the one I run is for people from New Hampshire, but I get a lot of people from other states as well. And it's Zoom opened my world. Zoom meant that I could run these support groups from home. And Zoom would allow people to give testimony here if you allowed it like other states. I just like to mention that. It is a real open door for people like me. But I'm in a lot of pain because I also couldn't take my medicines to drive. And I'm very strict with myself. I don't drink because my medications don't allow me to, and I'm not one who enjoys feeling lost or, out of control. That's not me. I wanted to get better, and I have learned through so much through U.S. Pain Foundation. It's more than just support groups. But in running these groups, I'd like to share some of the things that I've learned. I've learned more acronyms, more cases for chronic pain. People introduce themselves and say, I have CRPS, I have fibromyalgia, I have this, I have that, and many of us have more than one condition. And CRPS, chronic regional pain syndrome, in many cases, some of these patients had a bad ankle that they broke, had surgery for it. The surgeon somehow nicked a nerve or whatever, and it sets off pain that radiates and goes to other parts of their body. Now, that's not a medical definition, it's just mine. But in other words, some of these conditions are also provoked by surgery. And as you said, surgery's the most expensive, perhaps. The other thing about my support groups, suicides. When I have heard so many people who are so desperate when opioids were taken away from them because they were managing their pain. They were not addicted. In fact, I get data from New Hampshire every month. It says what's causing the deaths
what were the substances? Illegal fentanyl from China, from other countries, is number one. Mixtures of drugs, or somebody used somebody else's drugs. But very rarely will you see a pain patient there, because pain patients use it to make the pain go away. And I want to offer that U.S. Pain Foundation has a great website. They have a lot of people who volunteer, like myself, do not get paid, and they know a lot. There are pain management, comprehensive pain services management plan we talked about in this bill. They don't have an identical thing, but there are examples, and there are people who could advise. So that it's not like it's a desert and that you have to start from scratch when you look at this bill. Educational services, right there. Pharmacological and non-pharmacological. I want to point out something. I'm just sharing some personal stories. I hope you don't mind. Pain patches, lidocaine pain patches. They were 5%, and I got them on prescription. It was so wonderful. And all of a sudden they said, we're going to make it 4% is over the counter now. And 5% is only good for these two conditions. And neither one, I have a lot of conditions, but neither one for that. So I've been using 4%, and it makes a difference. I would love to get 5% again. And I would love to have it covered by medical insurance. I pay $2 a day out of pocket just for that. And I do it. And it's only 4%. So I'm just saying, these ways of changing things, you talk about prior auth and step therapy. I have a doctor who says he won't do prior auth. If the insurance company tells him about it, he's not doing it for that customer, who might be me, that patient. Doctors are put through so many things, and it's one more thing that they have to, go through. Mental health, mindfulness, meditation, these are all offered by U.S. Pain Foundation. And manual treatments, massage therapy. I mean, you would probably all like massage therapy, but I don't think it will be taken advantage of. We're limiting things to what, 12 episodes or 12 times that you can have this. And I think it would help. I get muscle spasms, and sometimes, I've eaten a dozen bananas to try, and magnesium and this and that, but wouldn't I love to have massage therapy and have a real therapist? One of my problems before, I thought, I can have acupuncture, but the people who were covered by my insurance were over an hour away. And in my condition, driving an hour is a lot. So all these things. One more. I was given invasive treatment that was more expensive, and I kept asking my doctor, can I please have aquatic therapy? I have heard so many good things about pool PT, and I couldn't get it, and I couldn't get it. And then finally, I said, this other therapy is not helping me, and it's expensive. Finally got pool PT. What happens when you go in a pool? Gravity's gone. It's there, but not as strong. And the pull on your body, you are moving lightly, and the pain subsides. And you can do exercises again. Coming out is hard, because then all the gravity pulls you down. But it's a definite remedy for people. You can build up your muscles and get a little bit further in your own health. I'm currently doing Tai Chi online. There are so many spinal cord injury foundations that offer exercises online for upper body that are free. So there are things that are in this bill that are also free and resources out there. So I just wanted to share that, because I don't want you to be overwhelmed by the thought of the costs, because there are people who do it for free and could help. There are other states who have similar bills, and they're ongoing now. So I'm happy to answer any questions, and thank you for letting me speak. I just want to say, having insurance coverage for more treatments of pain is critical for people with pain in New Hampshire. Please help.
Thank you very much for your testimony.
Thank
you. Chair will call on Amy Odell Wilson, representing the Acupuncture Association.
Around.
Bill was originally introduced to it. Good afternoon.
Good afternoon. Thank you for this opportunity to speak. For the record, my name is Amy Odell Wilson. I'm a licensed acupuncturist, and I'm also the vice president of NAHAMA, which is the New Hampshire Acupuncture and Asian Medicine Association. I'm on two hats here. One is the vice president, to let you know that we stand in support in NAHAMA of this bill, and also as a self-representative, as a licensed acupuncturist, because education in the state is necessary. There are still many people who don't know the benefits of acupuncture, don't realize the scope of the practice, what is necessary in the practice. So what I've handed you is the position letter from NAHAMA, and what I'm going to actually speak on are some very specific cases from my practice over the last 5 years. I came to acupuncture late in my life, and it's been an incredible journey. Listening to Dr. Nagel speak, there was a couple of things that I didn't think I was going to speak on, but I want to point out to you. First of all, on the back of the packet that I sent out or circulating around, there's a resource, there's a table. Representative Sullivan, some of the questions that you had, one of the questions was in comparing different modalities. The resource there's a citation to a bigger article. If you were to take that home, put it into the web, you'd find the article with the tables. I tried to print them, but the font was so ridiculously tiny, there was no way you would be able to see it. But at home, you would be able to. And they're comparing different non-invasive modalities and what is effective. And also in that packet is a chart that shows the usage of opioids across many different countries. And you'll happen to notice that South Korea and Japan has the least amount. And those are two areas where traditional Asian medicine is the highest. And acupuncture is used in also, as Dr. Nagel pointed out, they use things like Qigong and Tai Chi and massage and nutrition and herbal medicine. You also asked about the cost of things and thinking about that. And not that I have a particular study to hand to you, but as I go through different patients, I can tell you the cost of those things. And just to start out to think about a patient's in pain, they go to their PCP. In that treatment, maybe it lasted 15 minutes, maybe they're there for 30 minutes. They walk out and they're still in pain. And when they get the bill, several $100s to see that PCP, and they're still in pain. Then they go to a pharmacy or they get referred to another practitioner. They're still in pain, and yet they've had multiple office visits, $700, and nothing's happened yet. So in converse to that, I see people, they come in acute pain or chronic pain, and within one visit, I've knocked their pain down. And my visits aren't several $100s. And although it is true that acupuncture requires multiple visits in order to have long standing, that's different from patient to patient. Some patients come in once or twice, the pain's diminished, they're back to work, $160. Pretty low cost. Other patients come in a short sequence, maybe twice a week, for a short period of time. Their pain's knocked down, they're back to work. And it's still a lower cost than 1 or 2 visits with PCP. So here's just a couple of examples so that you have some talking points when you're talking more knowledgeably about acupuncture in the future. Some of the patients that I'm currently seeing, one's a 38-year-old male. He's a commercial pilot. He was serving in the armed forces. In December, he came up with radiating pain down his arm. There was no possibility of taking certain prescriptions or he would be grounded. He had gone to his PCP, was referred to PT, but PT was full, wouldn't be able to get in for several months. He went to massage therapists. Because of his muscle structure, his massage therapist wasn't able to work with him and referred him to me. And within one visit, his pain was knocked down and some of the feeling that he had lost in his hand had started to return. Within 7 visits between December and March, all of the radiating pain in his arm was gone. His hand was restored to full function. And it was 3 months after his initial visit with the PCP that he finally was able to get in for his scheduled MRI, which they found disc damage in his spine. But in 7 visits, we were able to restore the function of his arm, and the cost of that was $680. I have a 73-year-old who's had cancer 3 different times, massive cancer in her neck. When she came to me, her skin was about the color of the papers in front of you. She could barely turn her neck. She had no saliva from the massive radiation in her neck. Her oncologist referred her to an acupuncturist. And the first acupuncturist actually said, "I don't know how to help you." And then she got my name, she came to me, and we've been working. And I said, this is new for me, but we're going to go for it. I started to look at some evidence-based things that other people had done, and we started to work. Within 1 session, her saliva started to come back, not fully, but she had moisture in her mouth. And over the course of the time I've been working with her, the radiating pain has diminished. She's gotten the full color of her skin is back, range of motion is back, and one of the reasons she couldn't take some of the opioid medications is because they dry you out. So even though they're good for pain, it makes the saliva worse. I've been seeing her over the first 12 visits, was reducing that pain and getting her back to normal. And she has now been with me for 3 years on her own accord, and all of these are out of pocket. She did have another radiation kind of reset. She came back to visit with me again. And over the course of the 3 years that she's been with me, she's had just under $5,000 in out-of-pocket costs, but it's the only therapy that's been able to restore her function. A 28-year-old contractor who works on roofs, and he came to me with severe upper back pain. And although insurance does cover acute and lower back pain, they don't cover it unless you've had it for about 12 weeks. They don't cover upper back pain. It's only for lower back pain. And he came and said, "I can't go on any kind of medications because I need to work and be on the roof and be safe. I'm also afraid of addiction. I don't want to use any cannabis for the same reason." Within 1 visit, I had his pain knocked down. We talked about his stress, we talked about his sleep, and in just 3 visits, he was back to work. Total cost of $240. A 26-year-old who had his...
I'm sorry to interrupt.
Yeah.
Just in the consideration of time, we have a lot of people coming behind you. If you could just give us your final thoughts. Thank you.
I'll just summarize that acupuncture needs, part of the bill is talking about the repetition of things and having it qualified. And one is we need more than 1 visit. It needs to be covered. 12 visits might be enough. It might not be enough. The limiting factors of having a licensed acupuncture or licensed practitioner is necessary. And having a multimodal approach so that patients are able to choose. So if one thing isn't working, they can come and try something else. And I'll take any questions.
All right, I'm temporary chair for a few minutes here. Any questions from the committee? Okay.
Great.
I think we have a lot of
Thank you.
questions during the subcommittee. All right, next up, we'll call John Jor. Am I saying that correctly? John DeJour. And you're from the New Hampshire Psychological Association, and you support the bill.
Thank you, Mr. Chairman, members of the committee. For the record, my name is John DeJoy. I'm here representing the New Hampshire Psychological Association, and we are in fact pleased to support this legislation. The New Hampshire Psychological Association is the membership organization for licensed psychologists in the state of New Hampshire. I am not an expert on this, but Dr. Walter unfortunately was unable to make it and asked me to submit testimony, which I'm going to do. I'm going to excerpt one or two pieces of her testimony, and then I'll end my comments at that point. Dr. Walter points out the importance of this bill for pain management. She also points out the importance of the multidisciplinary approach which is taken in this legislation. In fact, those of you from last session probably remember the primary care behavioral health bill. This actually utilizes pieces of primary care behavioral health to have physicians and therapists working together. And we think that's a terrific approach to this. She mentions three other types of treatment, which I'll read them, but I'm not going to explain them. Pain catastrophizing, mental defeat, and psychosocial factors that apparently are important considerations in the treatment of trauma. And she's looking at pain management as trauma. She also offers to provide the American Psychological Association's clinical practice guide for treating chronic pain conditions. She gives her email in here. If anyone would like a copy of that, you can email her and she'll send you a digital copy. And with that, I will conclude my remarks.
All right, great. Questions from the committee for the guest? All right. Seeing none, thank you very much for your testimony. And next we have Cindy Steinberg. She's doing some pain management therapy right now, it looks like. And you support the bill. You represent the U.S. Pain Foundation, and you request 4 minutes to speak.
Thank you very much. I appreciate you listening to my comments. So I am from the U.S. Pain Foundation. You may have heard that we are a national patient organization. We have about 35,000 members around the country, people living with chronic pain from all different conditions. As you've heard, a myriad of conditions.
Pull the microphone right up to your mouth there.
Sure.
And there's a YouTube audience, so smile for the camera there.
Okay.
Thank you.
So as you've heard, people have pain from a myriad of conditions and serious injuries. In fact, the CDC has said in New Hampshire alone, there are 225,000 people living with chronic pain, and 79,000 of those have high impact chronic pain. That means pain that interferes with your ability to function on a daily basis. These people are devastated by their pain. They can't work. They can't take care of their family. They can't take care of their children. We're talking relentless 24/7 pain. And where many of you are talking about the cost of some of these treatments, think about the ability to possibly go back to work, to not be on disability. Pain is the #1 cause of disability in this country. And so it is a huge burden and huge problem. Now, many people here have talked about different approaches for treating pain. And I wanted to tell you about a task force that I sat on
where this idea of multimodal pain treatment comes from. And it's kind of this bill, which we strongly support, really backs that report. And that is, as the director of policy and advocacy for U.S. Pain Foundation, I'm often going to Capitol Hill. And when the opioid crisis hit, a lot of Congress people said to us, well, what's the problem? Why don't we just get rid of opioids? And basically what we said was, what else are people going to do? Because there hasn't been a new medication for pain to come to the market in more than a decade. And so you've got over-the-counter, and then you've got opioids. And in between, doctors often use things off-label, but there's a dearth of medications for severe pain. And so when this happened, Congress said to us, well, in this opioid bill, and there was a big federal opioid bill called CARA, we want to appoint an expert, a pain management specialist, to tell us what is the best way to manage pain now in this country. And basically, I was appointed to that. I was the only patient. Everyone else were pain doctors. It was headed up by a pain physician from Stanford University. And our conclusion was what you've been hearing in 2019, because it has become the standard of pain treatment now. And that is, we looked at all the possible treatments that fall into 5 categories: medication, complementary treatments, interventional procedures, restorative treatments like PT and OT, and behavioral treatments like the psychologist who just spoke here. And the conclusion was, you need to develop a treatment plan for each person with pain, because there's so many different reasons people have pain and so many different types of pain. And draw the treatments from any of these. And in each of those categories, we listed all the different treatments possible. And that, in fact, really has become the standard of care, which is, even when it comes to medication, you still need, it's not a panacea. It doesn't take away the pain. There is no cure for chronic pain. It is now known to be a disease of the nervous system and brain. And the best way to manage it is combining these treatments, as Dr. Nagel has said, and finding the best combination. And the way that works, and I heard this representative ask, well, what happens with that? How do you solve pain? If each treatment takes down your pain another 10 or 15%, and you combine those, the difference between having pain at a super high level and 50% of that pain might mean the difference between being able to work or not, being on disability or not. And so that really is the best way to manage pain. Yes, the psychologist who spoke, the acupuncturist who spoke, Dr. Nagel who spoke, those help people, but not everyone. Some people are helped by acupuncture. I happen to live with pain. The way I manage it is I take a medication called amitriptyline. I limit the amount of time I'm upright. My back was crushed in a serious injury. You saw me laying down. I alternate all day. And I do a water-based exercise program. And with those things together, I've learned to manage my life. And that's what we mean by self-management. We don't mean, oh, somebody has a severe migraine, just manage it yourself. We mean combine these different treatments, learn your own body, and figure out how you can bring down the level of pain such that you can function. And that's what we do at U.S. Pain Foundation. We expose people in the support groups, like you've heard Bobby, she's a terrific support group leader. And we teach them how to combine these treatments to bring their pain down to a reasonable level. And so that's why when the opioid crisis hit and all these people were being force tapered off of opioids, there were 5 to 8 million people using opioids, the NIH said, in 2014 before the CDC guidelines came in place. That has been reduced over 60%. And so many of those people were forced off, and we heard from desperate patients who were doing well on them, but can no longer get them. And doctors won't prescribe, and we're not going back there, really. We need new solutions. And so right now, while we're waiting for some new medications in the pipeline, and we're very optimistic that new non-addictive medications are in the pipeline and coming, because I think for pretty severe pain, you need some sort of medication in combination with other things. But really the best way is to manage pain by combining different things that work for you. And your physician should help you with those different things. I found somebody that helped me, and I combined those different things to manage my pain. Same thing with Bobby. She couldn't be here unless she had learned behavioral techniques and other techniques to help manage her pain, in addition to medication that she uses. And so that's how we teach people to be functional. And so this bill, which we strongly support, would enable people to get access to therapies that they can't get access to now because they can't afford them. And why not try these non-invasive, non-risky procedures? As we've talked about, surgery is often an option for people, and I've seen many surgeries go right, and I've seen many surgeries go wrong. I've been leading a support group for 24 years. I've seen many patients who've had multiple back surgeries, and they're still in pain. And then a lot of people are really reluctant to go to pain clinics because pain clinics these days only do interventional procedures. They've stopped prescribing. They don't offer these other options because they don't have the practitioners and they don't have the insurance coverage. And so most people, when they go to pain clinics, get injections. Like anything else, they help a small percentage, maybe 10 or 15% of the people, and the other people they don't help. And what we see is insurance companies readily agreeing to pay for nerve blocks, epidural injections, all kinds, trigger point injections, because that's covered and doctors get a fair amount of money for doing those. So they're willing to do those, but yet these other things aren't covered. So our feeling is this is a reasonable approach. We're saying 12 visits a year and of these things. And why not try these less invasive, less costly, less risky procedures like acupuncture, like behavioral treatment, in combination, with some other things. So in the long run, we think it's less costly. I have to tell you, in 24 years of seeing more than 600 people that have come to this little support group that I lead, everyone has been on years' journey to find help with chronic pain. I mean, it took me 5 years. I had so many tests and different procedures and nerve blocks and injections. And ultimately, what helped me was a doctor who said, let's try this water-based therapy, let's try this medication, and let's try limiting the amount of time you're upright and learning what your body needs. Right? People with chronic migraines can't handle a lot of lights or certain foods that trigger them. In combination with migraine medications and avoiding those things, they learn to manage their pain. So this is not at all what I was going to talk about, but I figured an answer to a lot of your questions that have been risen about how's the best way to manage pain, why, is this going to be more costly? I've tried to answer some of those things with this answer. And I think Dr. Nagel is a really terrific pain physician. He's told you the truth. He does interventional, but he has used these treatments and they've helped people. And I think he's done a really thoughtful job with this bill. And so, we strongly support his efforts with this bill. So I'm happy to take any questions that you have.
See none. Thank you very much. Okay. We've done the pro. Now we'll do in between. Michelle Heaton from the New Hampshire Department, which takes no position on the bill.
Thank you, everyone. For the record, my name is Michelle Heaton. I'm Director of Life and Health with the New Hampshire Insurance Department, and I have here Dr. Jason Azes, who is our Director of Health Economics. As Representative Hunt said, we don't take a position on this bill. There's just a couple things we wanted to point out with respect to our fiscal note. So this statute aims to
Just so you
amend-
know, we have not seen the fiscal note.
Oh, I thought it was on
What's on I
the
don't know.
bill that got posted. I
No,
think if you
what's
look right
on
now.
what we have right now is all the zeros.
Oh, well, when I looked it up, it may have just gotten
Online.
posted
So you
this
went
morning.
online?
Yeah,
Is it online?
I believe so because I just pulled it up.
Okay, great.
But I can
That's
walk
good.
you through it. So,
Give us the highlights.
It aims to amend two different statutes, 415.6 by adding a new section and 415.18. So that's individual and group. To the extent this creates new mandates for the individual and small group market, those are benefits in addition to EHB in some respects. Some of the stuff mentioned in this bill is already covered by insurance, but I think there's some areas that are not and are not part of our benchmark plan. So to the extent it expands what we're already required to offer, it could be subject to defrayal by the state, and that's a cost that the state would have to take on. It's indeterminable because we have no idea of estimating what that would be. We can do a mandate analysis, but that would require you guys to direct us to do it, and those typically cost the department between $20,000 and $40,000 to conduct a mandate analysis. So we'd encourage you to do that sparingly. Another aspect of this bill is that there's a requirement that they file that carriers make certain filings with us, and that we would approve some of these filings as clinical guidelines. We do not have expertise on staff to review any kind of medical necessity type things or to weigh in on the medical appropriateness of any kind of clinical guidelines. So that would be something that would be difficult for us to approve. And we would need probably $250,000 in addition to our budget to outsource this work to the appropriate vendor.
To have a medical director on staff, right?
Yeah, we wouldn't be able to hire one, but we can outsource some of this work. I don't think it's a full-time job, but we could get a vendor to do it. But it's going to cost money that is currently not accounted for in our current budget. So there is an added expense there. So I think those are some of the highlights. And Jason, do you want to add anything?
No, unless you have questions.
Great, thank you. Okay. Okay, now we have the dart throwers. All right, Andrew Osmer, representing Harvard. I was going to say you were my favorite senator, but I see I have another senator in the room. I get two now.
Well, Dr. Nagel has a top 10 of friends, so long as Senator Kavanaugh and I make your top 5 senators, we're good with that. Good afternoon. My name is Andrew Hosmer. Today I sit before you representing Harvard Pilgrim Healthcare, Point 32, which is New Hampshire's largest nonprofit insurer. So I will try to keep my remarks brief, knowing this is going to subcommittee and there's still an awful lot of work to do. But I will say to all of you, Mr. Chair and members, Harvard Pilgrim strongly supports pain management services that are alternatives to opioids. However, we believe this bill is unnecessary because insurers already cover a wide range of pain management treatment options, including most of the services listed in this bill. We support a wide range of evidence-based treatments for pain management as alternatives to opioids. Harvard Pilgrim, in its robust array of programs, covers things like physical therapy and occupational therapy, chiropractic care and acupuncture, behavioral health care, including counseling and cognitive behavioral therapy. While we do not cover meditation, though, through external providers, mindfulness meditation resources are available on our website and accessible to the general public. It's not just for our members. The resources include essays about uses of mindfulness for managing chronic pain and recordings of guided meditations, Though sometimes portrayed as hardened of heart, certainly listening to people testify today, it's easy to feel a great deal of empathy for folks who are dealing with chronic pain. And I will say to you that as part of our mission is at Harvard Pilgrim, is that patients must receive the highest quality health care and improving outcomes all the time. I'll also let you know we also provide coverage for many FDA-approved prescription non-opioid drug products that are effective pain management alternatives and have a lesser potential for misuse than opioid drug products, including topical analgesics and corticosteroids. Harvard Pilgrim already has an easily accessible member-facing website specifically addressing pain management that links members directly to their specific benefits page so they can understand the coverage that they have. Also significant in this is insurers design plans that meet the needs of their membership. While every plan may not cover each pain management service, there are a variety of plan types with varying benefit designs, allowing members to choose a plan that best meets their needs. This allows insurers to meet the needs of their membership while also keeping costs as affordable as possible. While we appreciate Representative Nagel's goal of increasing access in a cost-effective manner, there will be an increased cost when any new benefit is required or mandated. Even if there is a low cost with this mandate, one thing that we take into consideration is the cost of other mandates the state passes this session, and add that cost to the mandates passed in previous years. When considered in totality, it all adds up to a significant cost to employers and consumers in this state. I think finally, as well, we need to consider the ability of some of these provider types to submit claims for their services. For example, this mandate would require us to cover massage. While massage therapists are licensed in New Hampshire and certainly do provide benefits to those with pain management or in their pain management, are they really in a position to submit claims for reimbursement through our operating system? If not, it'll be challenging for Harvard Pilgrim to build an adequate network that satisfies some of these sole providers or smaller practices. With that, I will conclude my testimony on behalf of Harvard Pilgrim Healthcare. I'm happy to take any questions that you may have.
We just want your testimony.
I will provide it at some point here. It's
In the term.
absolutely. Any
Okay.
questions? Thank you very much.
Thank you. Chair will call on Sabrina Dunlap from Anthem.
Thank you, Chairman Hunt. Members of the committee, my name is Sabrina Dunlap. I'm Director of Government Relations for Anthem. And I just wanted to say we've been working on this bill or a version of this bill for many years. I was talking to Rep. Nagel about when did this first appear. I think it was 21 or 22. And I think the bill has come a long way, and certainly we've been part of work groups and had very good discussions about these issues. I think there's still problems with it. I'll try to be brief. I echo much of what Andrew already said. But first off, again, we already cover many of the services listed here: chiropractic, acupuncture, ACT, CBT, and others as well. And, you know, we want members to have access to these sort of alternative treatments. I think there's only so much you can do as an insurance company. And at some point it comes down to providers and what are they pushing. There's a bunch of practical issues. And one I would mention is network problems. I know acupuncture is covered. We do have challenges trying to get acupuncturists in network. We can't force them into our network. So that's just a practical problem I suspect would play out with others, you know, like massage therapists. Again, some of these services are not exactly medical in nature, like mindfulness. I know yoga is probably going to be taken out, but how do you define these things? There's licensing issues. There's the network problem. How do you bill and code for these services? Many of the services are self-directed by the member, so I'm not sure how you account for that. There's some issues with the bill being too broad. I know some of those things have already been discussed. I would just flag the effective date, I think is July 1st, 2025, which would be challenge. And I'd also add this will only apply in the fully insured market, which I know we talk about a lot, but you know, it's more pressure on a small segment of the overall insurance market. And I think it's worth noting when people say like these things aren't covered, it really depends on the type of plan somebody has. It varies widely by plan. And certainly if somebody had a self-insured plan, this bill would not change, potentially would not change anything for them because it would not apply. So you know, happy to continue the conversations and try to be helpful in any way we can on this bill. But I don't think insurance coverage is the problem, and I don't think it's the solution. I think, again, this is probably more of like a provider education and sort of culture around how we treat pain. So thank you for letting me speak, and I'm happy to take any questions. All right, thank you.
Thank you. One more card left, Paula.
Thank you, Mr. Chairman, and good afternoon, members of the House Commerce Committee. For the record, my name is Paula Rogers, and I'm here on behalf of AHIP, America's Health Insurance Plans, which is a trade association of health insurers. And you've heard from a couple of members, Anthem and Harvard. I was interested in Representative Hunt's comment about perhaps some way to enclose what's going on here in a sort of cogent way that would deliver some results. And so before the hearing, because I've been involved years back on the very same issue with Dr. Nagel, I spoke with him and I said, you know, I know there was a bill. I looked at the legislative history from, I think it was 2 years ago, went to interim study and then now recommended for further legislation. And the bill has made significant progress. It was rather expansive and difficult to see how you could fit the framework of that bill into a regulatory setting. And I'm having sort of a continuing problem wondering what is going on that we can't do something. So I'm hoping I can leave copies maybe later this week, but I Googled about and I found a Journal of American Medical Association article very recently published, I think it was October of this year, but released for publication earlier in 24. And it has a survey of states that have been doing just what this committee is trying to do. And there are only 7 of them that they picked up. And none of them has really reached a place where they feel they've listened to everybody and they've come up with something that will make a difference, or they're not confident enough that they have. So when I was listening to Dr. Nagel, it suddenly occurred to me, and then it was prompted by Chairman Hunt's comment. Some of you were probably in a legislative setting when integrated primary care was discussed. That is weaving behavioral health care into the primary care setting. I heard statistics today, and I've been Googling about it, found the number of people that are suffering with chronic pain, looking for treatments. And so if there are that many people, why isn't there some interprofessional discussion going on amongst providers, including Dr. Nagel, including primary care physicians? If a patient comes to you, which is where most people go because they start with their primary care doctor, and they have chronic pain, yes, you can see them, but you need to already have in your mind as a professional with an integrated view of the world, if this person has pain, do I begin to tell him or her what the alternatives are, and do I deal with, in an integrated behavioral situation, there's a care manager, there's the specialist, there's the primary care provider. That needs to encompass this challenge, because I was shocked when I saw the number of people that are chronically in discomfort. So when I spoke with Dr. Nagel, I indicated that AHIP would be happy to continue in a conversation, and I don't think people should sort of give up and throw up their hands. There may be something that can be done that would sort of begin to formulate something to address the people that came here and testified who are struggling. So I'd be happy to answer any questions, but I don't have many answers, so.
So I was thinking that the best way, if we were to try to direct patients to go think about, would be through copays and deductibles. And their show, you know, and with using those as a way for a patient to help them see that doing something alternate, you know, would be a better way to do that, rather than going directly to the surgeon.
Exactly. And so in a primary care setting with the sort of umbrella of understanding that this person presents with a discomfort and chronic pain.
the pain,
What are my alternatives out of
Right.
primary care? And have I sort of internalized that? And can I aid
Well,
my
we can't
patient
expect
to-
so much of the primary being knowledgeable about copays and deductibles.
No, no,
but
but-
that they refer them to the in terms of the insurance company would then have or maybe have something in the primary careers office, or have something that some notification where they would get a list of how we want to direct them to think about doing these alternatives before going to that surgeon.
I think that's the sort of discussion that we should engage in.
Yeah.
Because we can be creative and
Be
perhaps come
creative
up with
using
something.
then those and our carrots is the or in this case it could be the hammer, but that in terms of the deductibles and copays is to get them to think one versus the other initially. That's what I'm thinking.
Thank you. Thank you very much. Whoops.
Yes, Representative Gibbs.
Thank you, Mr. Chairman. If I understood correctly, you were talking about a large part of the problem being lack of coordination among providers. Did I understand that correctly?
I think there needs to be more interprofessional discussion about pain, because I was shocked when I heard the statistics. So primary care physicians must encounter it frequently.
Follow up?
Further
Thank you.
question may inquire.
Thank you. Do you have any suggestions as to how that coordination could be done?
Well, I think that's a question that should go back to the professionals, because if it's a challenge for caregiving, then just like behavioral health, which, 4, 5, 6 years ago, the federal government developed a healthcare model for an integrated practice for behavioral health problems, which have a similar kind of, in fact, there's behavioral health counseling that's helpful for pain management, but it's sort of a more nebulous thing you're treating, and there are an array of opportunities to have a positive effect. Well, then interprofessionally, that ought to be more, the primary care practice ought to be more comfortable with understanding the array of things. And of course, if it comes up, then the insurance coverage sometimes is a difficult thing, and that's a coordination issue with a office manager. So I don't have the answers. I just know something's missing.
Thank you.
So, thank you, Paula.
Okay, thank you.
So, Representative Nagel, we do have one more bill we got to get through here, but
This will be really quick.
okay.
So the only
We'll see
reason
how-
I'm here is to solve that problem.
Get it? You have to speak to the
Oh,
mic.
yeah, sorry. Is to solve that problem. There's a number of moving pieces that are ongoing right now to look at how do we coordinate all of our resources within the state so that we work together as a team rather than as silos, because siloization is a huge problem in the state. So we are looking at that in about 4 or 5 different ways. So don't worry, we're working on it. We'll solve it.
Okay.
We are.
Great.
Thank you.
Okay, having no more cards, I will close the public hearing. And we have one more bill left. The sponsor has left the house. So we'll have the insurance department she told me that you guys requested her to put this bill in? Yeah, okay. So what I'll do is I will read her testimony in so it's officially in on YouTube, and then you guys can make your presentation. This bill, the request of the insurance department was to strengthen New Hampshire's program for collecting and de-identifying health insurance claims data from all payers. New Hampshire was one of the first states to establish an all payers claim database, known in other states as APCD, but known in New Hampshire as CHIS, Comprehensive Healthcare Information System. The CHIS has been essential to the state's efforts to make healthcare costs and spending more transparent and to support evidence-based policy making. Under Employee Retirement Income Security Act, ERISA, states are limited in authority to collect data from employer plans that are self-funded. In order to address this limitation, the New Hampshire legislature created an opt-in program in RSA 420 G11, Roman numeral 5, whereby self-funded employers can opt in to providing their de-identified claims data into the comprehensive healthcare information system. To strengthen the opt-in program, this bill provides that any self-funded employer that opts out of the system, it will have to access their own claim data. Self-funded employers often use this data to improve their employee health benefit plans, but sometimes run into problems that the claims administrator treats the claims data as proprietary and not available to that self-funded employer. Under this bill, by opting into the CRIS program, a self-funded employer will no longer have this problem. Excuse me. Your title, I'm sorry, I remember trying to remember what your title was.
Director of Life and Health.
Director of Life, yeah.
So, well, hello, everyone. Again, for the record, my name is Michelle Heaton. I'm the Director of Life and Health at the New Hampshire Insurance Department. And I have here with me Dr. Jason Aziz, who is our Director of Health Economics. This is a bill that we have asked Representative Spear to bring on our behalf. And what we're trying to do with it is to strengthen the amount of data we're getting in our CHIS system, our all payer claims database. Under ERISA and federal law, we are not allowed to require self-funded plans to submit their data. They have to opt in. And that's been the law for some time now, after some federal cases came out. So what we're trying to do with this amendment is to give an incentive to those self-funded plans to opt in and give us their data. And the incentive is that if you do opt into the system and agree to submit your data, then we will give you your essential cut of the data so that you can look at your own claims administration. So we think this will be able to absorb any additional administrative functions already in our current budget, so we don't think there's going to be any kind of fiscal impact for it. So, and Dr. Jason Aziz is the one who really works closely with the CHIS and can answer any of your questions.
So you're the new Tyler Brandon then?
Yeah, as of 3 years ago. I just wanted to point out, right now, I think there's a misconception that the CHIS only contains the fully insured data. About 28% right now of the CHIS are self-insured members of the state. And so it's a really high utility health information data set. And by strengthening it this way and having greater representation of this self-insured market, it only gets better and more utility for this committee and the citizens of the state.
One more thing I want to add is that on this bill, the effective date is 60 days after passage. In speaking with industry, they would prefer for that to be
Beginning of the year.
January 1. We have
January
no
1.
objection to that. So if you
Right.
want to make an amendment, that's fine with us.
So I think this is a good way of looking at the bill, even though I know that behind the bill there was a different issue that was what this is about. But I would say that one of the things that I know in the past when it came to this data being released, and especially when we talk about a single employer and getting employer information. So in this case, you're saying the employer's not going to get it. You're going to get it, or is the employer still going to get
No,
it?
we would give the employer at the end of their plan year, we would give them their data back.
Right.
So we would be able to facilitate that for them.
Which is what they were looking for. And I would just say, I want it on tape, that the one of the underlying issues why that was always considered uncouth, because some employers could then figure out which employee was costing them all that money by looking at that data. So that was always a sore point that why they were not being given the data is that that they don't want the employer to say, well, gee, I can't believe that employee cost us that much money. But most employers with RISA have a stopgap coverage, and so they wouldn't know it until the gap coverage got kicked in. But it is a problem of being a self-funded plan and having that claims data. So, okay, any questions? Yes, Representative Teresa.
Thanks for taking a question. So I have a quick, I just want to understand this, by self-funded employer health benefit plan means people who buy their own insurance from marketplace, or is it something different?
No, these are employers that keep the risk with them, so they agree to cover all healthcare costs for their employees. So they don't purchase large group insurance products, which is what we regulate. They keep that risk for themselves, and it's up to them to design and implement those plans.
So the history is this is actually goes back to Gerald Ford when he was president. He signed the legislation. It's a federal plan, and it was available to obviously to initially people would think it was only like employers who had 200 or 300 employees. I've heard that it can get as low as 50 employees. It can get fairly down there, but the reason being is that the employer is now taking on the risks of having too many sick people in their plan, and that's why they all what really opened the floodgates is the stopgap coverage that they would also purchase. But for all intents and purposes, this is something for a large employer who chooses not to have a fully insured plan. You still use Cigna and Anthem as in terms of what the card that your employee will get. But in the end of the day, they are exempt from all our state regulations because they're really a license, or if license we'd call it loosely, but their incorporation status is of that plan is federal.
Okay, so let me understand if I understand correctly. So this plan is basically the employer.
Employer's plan.
They don't go to insurance companies.
They use an insurance company to be their billing and paperwork and processing, and then paying out the bills. So they still hire a separate insurance company, but it's not regulated. It's not the status is not under let's say the Affordable Care Act, which is state based, or the marketplace, which is for individuals.
Yeah.
Okay. In this case, it's just a whole nother separate entity of regulation. You would say that the federal government does not do a lot of regulating on these RISA plans, and we do hear complaints every once in a while. But the most classic story you'll get is someone says, "Well, gee, I thought New Hampshire passed that mandate," and find out that that's just because we passed it doesn't mean it happened with that employer, because of that large employer, and especially really where the legislation really came out, it was employers who were in multiple states.
Yeah.
And so they didn't want to have a different plan for every state. They want to have one plan for the whole company. And that's where the ERISA was supposed to be out of, I think, was really what was why it was created.
So
it was for large employers who were in multi-states.
So I'll try to get some more information. I'll read about it, but typically when an employer takes a plan from an insurance company, it submits all its employees' information to the insurance company. That I have 10 employees, and this is the information about 10 employees to the insurance company. This is different than that.
So you're saying, do you get your information of those 10 employees?
No, usually when an employer purchases an insurance plan,
right,
then the insurance company asks them the information about, suppose there are 10 employees, they'll ask information about those 10 employees. All
when you say ask information, let's make sure we understand what you're talking about. Are you talking about medical underwriting?
No, they ask about, everybody is insured. All the 10
correct. All the employees are insured
because it's an
yes.
employer plan.
Yes.
But the insurance company still gets the information, name of the employee, social security number, whatever, all those information.
Oh, yes, that's true.
So they get, so this, are we talking the same thing, or this is a different kind of plan we're talking
so
about?
Again, in terms of what we're talking about, in terms of, if you're asking me, let's say, what plan you have. So how many employees do you have?
So suppose there are 10 employees.
You have 10 employees, so you're going to be in the small group market.
Yeah, so
you're not going to go to ERISA plan.
So
ERISA plan, you're going to get the plan not from a benefits manager. It's a different. You're shopping in a different location.
Okay, so maybe say I'll get more information on this. But what is the objective? Let me ask you the last question. What's the objective of this bill actually? Why do you want to get the claims data? What's the objective of this bill?
Well, there was a federal law, I think in 2017, that precluded large self-funded plans from having to submit into the claims data. And as a consequence, there's a lower amount of representativeness in the claims data from those plans, which in New Hampshire, I think is about 54% of the commercial market is self-funded.
Yeah, it's like 50, yeah,
We do a
yeah.
good job in New Hampshire getting some of the self-funded data in there. I think largely because of the state employees plan and the corrections and maybe university system of New Hampshire, but we still need to strengthen the representativeness of that large segment of the market, and that's why I think this is important.
However, having said that, in terms of the part where I was asking, talking about how does the employer at the end of the day get the same data? Okay, because if you're in the regular small group market, no, the employer doesn't get the data. Okay, the state compiles it as a mass database and really uses it to help you shop around and see what hospitals, what doctors, are you're using the best, costs for your employees. The larger employer who's in the ERISA, they want to be able to shop their plan. And they want to use different ERISA, benefit, managers to get different plans. And the best way to shop it is to be able to take your medical history of your employees and take it to multiple plans.
And so in
So that's
some
why
cases-
that's the second side of this legislation.
Yeah, they lack their claim insights on their claims experience. So it would be, as a fiduciary, which a lot of self-insured large employers are, that knowledge is probably high value for them, and they don't always get it from their contractor, the insurer that they contract with as a TPA.
Right.
As a note to understand that enigma a little better, in the claims data, we classify those insurers that act as TPAs as either ASO or ASW, which means administrative services only, or
Right.
administrative services with some other kind of rudimentary functions. So they just administer the benefits, whereas the employer takes on the financial risk of the underlying health conditions of their workforce.
Now, some question, was this one for the municipal ones, like the Primex, or was this for all ERISAs?
We don't have a clear awareness of who doesn't get their claims data from their
Right.
contracted
My understanding
TPA.
was, that this legislation was being driven by one that does municipal, which is Primex.
Okay.
But
Thank you.
okay. Yeah,
Just
municipalities. That's what
last one.
Primex is.
So for self-funded, if the company is in multiple states, still we monitor it, or how does it work?
It depends. There are large group plans that may operate in multiple states. Our CHIS is Citus based.
Citus-based, so yeah, we have a lot.
Yeah, so it's all plans Citus in New Hampshire. We are already collecting that data for fully insured plans, which it could include a multi-state employer. If it's a self-funded plan, the only way we're getting that data is if they have opted into our system and are agreeing to voluntarily give us that data. And this bill is aimed to give them another incentive to opt in because we can't require them to.
Tins. I'm sure. What was it? What were you calling this?
Sorry.
Yeah. What you sound like you used the word chins or something.
CHIS?
Chiz. Yeah. What's chiz?
That's the
That's
database.
that's the
That's
database.
the name
itself.
of it.
Right.
yeah.
That's the actual database.
CHIS?
I should know
Yes.
since I was the sponsor of it.
What is it?
New Hampshire, make sure we put the New Hampshire, because Massachusetts has a CHIA, and I think
Right. Everybody has
Mississippi-
a different
but
variation.
New Hampshire CHIS is New Hampshire Comprehensive Health Information System.
Right.
And I'd like to point out too, it's not just the claims data that's part of the CHIS. There's other types of data that are included in that, and accordingly in our statute that this bill aims to amend.
Right. But the goal was to try to figure out how to, because it's to say, well, how much does a procedure cost at a certain hospital? Well, you have different factors. You have the doctor, you have the hospital, and then you have the anesthesiologist. So it was trying to collect all that data so we could really, truly analyze what certain hospital groups, what things were costing, so that you can, and you can go online and see see, choose which is the best hospital. And then we had the outcomes too. We have the outcome report, which is which can be a little misleading, because if a hospital doesn't do a procedure as often as someone else, as another different hospital, and has one bad case, it could throw it into the bad outcome category. but at least you get an idea of, you know, of what the hospitals are going to cost you, what it's going to cost for a procedure. All right, we all set? Thank you very much.
Thank you.
Close the public hearing. And like I said, the subcommittees for these bills will be in 2 weeks.